Good morning, everyone, and welcome to the 16th meeting of the Justice Committee. We have no apologies. Agenda item 1 is consideration of an affirmative instrument, legal aid and advice and assistance, miscellaneous amendments, Coronavirus Scotland Regulations 2020 draft. I welcome Ash Denham, Minister for Community Safety, and her officials, Kieran Burke, Team Leader, Access to Justice, and Martin Brown, Solicitor, Scottish Government Legal Directorate. And I refer members to paper 1, which is a note by the clerk, and invite the Minister to make a short opening statement on the instrument. Minister.
Good morning to the committee. Thank you, Convener. So these regulations will introduce temporary amendments to existing legal aid legislation to help support legal aid providers during the coronavirus pandemic. The committee members, I'm sure, are well aware of the important role of legal aid providers in supporting their clients and also the Scottish justice system, and also of the Scottish Government's stated aim of finding ways to support cash flow for legal aid lawyers. And that's why in the Coronavirus Act, primary legislative changes to the Legal Aid Act of 1986 helped extend so-called interim fee arrangements to help facilitate cash flow for legal aid providers. And it was right that with uncertainty as to when cases could be able to conclude, the payment be accessed for services that had been provided to date. Within secondary legislation, residual barriers exist that prevent payment of interim fees for aspects of legally aided work. And so these regulations will remove these barriers. Regulation 2 will do so for work in respect of civil legal aid at Sheriff Court. Regulation 3 will do so for criminal legal aid work undertaken by advocates. Regulation 4 will also enable payment of interim fees in advice and assistance matters, despite there being a possibility that property may be recovered or preserved or expenses obtained. In such cases, normally there's only recourse to the fund if payment for the legal services provided cannot be met through these other means. And this change will align these advice and assistance matters with other aid types in terms of accessing interim fee arrangements. And to safeguard the legal aid fund, there are recovery provisions so that in the event that ultimately property is recovered or preserved or expenses obtained, there will be repayment to the fund to reflect the monies it would not otherwise have made available. My officials have worked closely with the Scottish Legal Aid Board, and it's understood that involved system development is required to give effect to this change, so a later coming into force date of the 5th of August 2020 is set. Given expectations to adhere to social distancing, travel restrictions, not to mention self-isolation, provisions have been developed to facilitate greater delegation by solicitors. And the Criminal Legal Assistance Regulations of 2011 prohibits delegation to a duty solicitor by a nominated solicitor, although the services of another solicitor may be sought if a personal appearance cannot be given effect under certain circumstances. So Regulation 7 will extend this provision to all solicitors, including duty solicitors, during the emergency period. And in the interests of the health of individual solicitors and wider public health, it's appropriate to facilitate such delegation can occur where necessary. Regulation 5 makes provision for payment of a full fee in the event that a duty solicitor is instructed, when otherwise a half fee would have been payable. And this is in cases where the duty solicitor makes an initial plea of not guilty on the instruction of another solicitor, and that solicitor later tenders a plea of guilty prior to trial. During the emergency period, a solicitor with a pre-existing solicitor-client relationship will receive the full fee, even where they do not make the initial plea on their client's behalf in person. And finally, these regulations will enable non-means tested assistance by way of representation to be available to individuals with a right of appeal to a sheriff, where special requirements or restrictions have been imposed as a consequence of coronavirus legislation. And these will help facilitate access to justice and align with the policy of non-means tested APOR being available in other areas where civil liberties are subject to restriction, such as detention under mental health law. So ABOR is solicitor granted without determination by the Legal Aid Board. So I hope that has been a useful overview for the committee. Thank you, Convener.
Thank you, Minister. Do members have any questions or comments? Liam Kerr?
Thank you, Convener. Thank you, Minister. That was indeed useful. I just have a very brief question. This SSI temporarily amends the pre-existing regulations on legal aid, and the intention is, as I read it, that they expire in line with the Coronavirus Act. Now, in order to do that, looking through the regulations, each clause has a definition of the emergency period, with one exception, Section 6. Now, I suspect I know why that is, but could you explain, just to relax me, why Section 6 does not have an expiry, but every other section does?
Minister.
Yes, the member is quite right. So it will expire in accordance with the Coronavirus Act. And you'll see that, as I've explained already, some of the regulation, well, most of the regulations, the emergency period is started from the 1st of July, and one of them is from the 5th of August. But I'll let one of my officials come in and just give a fuller explanation of that to the member.
Kieran or Martin, would you indicate?
Good morning. The regulation in question is provides for an appeal where there are measures taken under the UK 2020 Coronavirus Act, and when that act expires, the provisions will no longer be required, essentially, so there's no need to make them only available for a certain time.
Okay, thank you. Liam Kerr, does that answer your question?
Possibly. I think I know the answer. I think Martin, if I'm hearing you right, it's because unlike perhaps the other sections, one would have thought there's almost a natural expiry on this section by virtue of the matters that it's dealing with. Can I just confirm, is that basically what you're saying? There's no need for a bespoke expiry because by definition there will be a natural expiry by virtue of cases not... There will be a finite point at which cases won't hang over from the Coronavirus Act. Is that what you're telling me?
Martin.
Exactly. The 2020 UK Act, this will only be in effect for the period of time in which that Act has an effect, and the measures that this is providing legal aid for will only be possible while that Act has effect, and therefore it will no longer be required on the expiry of that Act. So it has a natural expiry in effect, which I think is what you're saying. So yeah, that's correct.
Okay, I think we've resolved that one, thank you. No other members have indicated they wish to speak, so we now move to agenda item 2, which is formal consideration of the motion in relation to the affirmative instrument. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and has no comments. The motion will be moved with an opportunity for formal debate if necessary, and the motion is S5M-21964 that the Justice Committee recommends that the Legal Aid and Advice and Assistance Miscellaneous Amendments Coronavirus Scotland Regulations 2020 draft be approved. I invite the Minister to move and, if necessary, speak to the motion.
Formally moved.
Thank you, Minister. Do members have any comments or questions? No. The question is that motion 21964 in the name of Ash Denham be approved. Are we all agreed? We are all agreed. Is the committee content to delegate to me the publication of a short factual report on our deliberations? You are content. Thank you. Agenda item 3 is consideration of a negative instrument, the Prisoner and Young Offender Institution Coronavirus Scotland Amendment Rules 2020 SSI 2020/175. I refer members to paper 2, which is a note by the clerk. Do members have any comments on this SSI? No comments, therefore are members content not to make comments to the Parliament on this SSI? And I see that we are content. That concludes consideration of SSIs. Agenda item 4 is the Children's Scotland Bill Stage 2 proceedings, and we'll now move to this main item of business today. I welcome back the Minister for Community Safety, Ash Denham, and her officials, and I also welcome a number of MSPs who are not on the committee but who have lodged amendments today. So welcome to the meeting. We have a lot of amendments to consider this morning, and we will work well if we take it slowly and steadily. When I call you to speak, please take a moment to allow your microphone to be switched on. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment, and to speak to all the other amendments in the group. Can I remind members who have not lodged amendments in the group but who wish to speak to request to speak by typing R in the chat box, the BlueJeans chat box function. Please do this as soon as I've called the relevant group, and please only speak when your name is called. I will invite the Minister to contribute to the debate just before I move to the winding up speech. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Only committee members are eligible to vote, and voting will also take place using the BlueJeans chat function. Once I've read out the result of the vote, should you consider that your vote has been incorrectly recorded, please let me know as soon as possible, and I'll pause to provide time for that. Depending on how long proceedings take, I'll suspend the meeting for 5-minute comfort breaks at suitable points. Given the time constraints, can I encourage short, succinct contributions from all those who speak today? Right, we'll now begin proceedings on the Children's Scotland Bill. Group 1, having regard to the voice of the child, I call Amendment 1 in the name of the Minister, group with amendments as shown in the groupings. Can I point out that if Amendment 47 is agreed to, I cannot call Amendment 2. Minister to move Amendment 1 and speak to all the amendments in the group. Minister.
Thank you, Convener. So the amendments in my name seek to strengthen the bill to ensure that a child's views are heard in family court cases and children's hearings, and this is obviously one of the key aims of the bill. So amendments 1, 3, 5, 7, 9 and 10 give effect to a recommendation in the committee's report to strengthen the provisions in sections 1 to 3 of the bill to ensure that all children who are capable and who wish to do so have the right to give their views about important matters affecting their lives. Amendment 4 removes the presumption from section 11 of the Children's Scotland Act of 1995 that a child aged 12 or over is presumed mature enough to make a decision as to whether to instruct a lawyer. This was called for by the committee in its Stage 1 report, and it was not the intention of the 1995 Act that the presumption should operate as a barrier to children who are under 12 making decisions on legal representation. But as the committee has heard, there is a perception that it has had that effect. Amendments 37 and 38 ensure that the views of the child are heard when the court is investigating the reasons for non-compliance with an order under Section 11 of the 95 Act, such as a contact or residence order. It's the Scottish Government's intention that all children who are capable and who wish to do so should be able to give their views on matters such as who they live with or have contact with. But I would stress that, of course, there will be circumstances where a child doesn't want to give their views on these issues and they shouldn't be forced to do so. The Scottish Government's view is that the majority of children are capable of forming a view. However, there may be exceptions to this, for instance, where a child is very young or where a child has severe learning difficulties. And for that reason, the bill provides that decision makers are not required to seek or have regard to the views of the child if the decision maker is satisfied that the child is not capable of forming a view. But we would expect this exception to be used very infrequently. I've listened carefully to the arguments put forward on these provisions at stage 1, and these amendments address concerns that this capacity exception may be used excessively by making it a starting point for decision makers that all children are to be presumed to be capable of forming a view. I cannot support amendments 47 to 51 in the name of James Kelly, but I would be willing to work with the member ahead of stage 3 on that issue. The intention behind his amendments is to ensure that children can, where practicable, express their views in their preferred manner. And as Mr. Kelly's amendments go some way towards recognising, it will not be reasonable in every case to allow a child to express their views in their preferred manner, for example, where that would significantly delay proceedings to the detriment of the child's best interests. The difficulty I have with Mr. Kelly's amendments is that in order to achieve the result, they would remove the text from the bill that says that children must give children, the court, must give children an opportunity to express their views, and replace it with the weaker requirement that courts merely seek to make reasonable arrangements for children to express their views. I'm sure Mr. Kelly doesn't want to weaken the duty on the courts to have regard to children's views, and so I hope he will agree not to press his amendments 47 to 51 today, so that we can work together on amendments that would not have that effect. So I move Amendment 1, Convener.
Thank you, Minister. James Kelly to speak to Amendment 47 and other amendments in the group. James.
Thank you, Convener, and I speak to Amendments 47, 48, 49 and 50 and 51 in my name. Section 1 of the bill deals with proceedings in court and children's hearings. The primary objective of the bill is to place the child's views at the centre of these hearings. As the bill is drafted, in my view, is not strong enough in that it seeks to give the opportunity for children to express their view, and my amendments, I believe, are stronger because they're more specific, and in two regards they seek to set out arrangements for the child to give their view, and also have regard to the manner in which the child will want to put their view across, bearing in mind that this will be a pressure experience for children, and many are vulnerable children in this situation. I think it's important that there's proper regard for the arrangements for children to give their view, and also the manner in which they'll give their view. And I do believe that the objective of these amendments is to place a duty on the court to do so. I think they also have to be aligned with proper resources to ensure that this can happen. These amendments have the support of Children's First and Women Aid, and they seek to strengthen the bill. And with that, I move amendments 47, 48, 49, 50 and 51 in my name.
Thank you, James. No member has indicated that they want to speak, so Minister, to wind up. Minister.
Thank you, Convener. I don't agree with the argument that's been put forward there by James Kelly, but my offer stands that I am happy to work with him ahead of the next stage if he feels that would help to address his concerns going forward. And just to reiterate to the committee that the bill drafting follows the wording of Article 12 of the UNCRC by providing that decision makers must give children an opportunity to express a view in a manner that is suitable to them. Thank you, Convener.
Thank you, Minister. The question is that Amendment 1 be agreed to. Are we all agreed? If you are agreed, please stay silent. To indicate dissent, type N in the chat box now. No one has indicated they dissent, so Amendment 1 is agreed. We now move to Group 2, call Amendment 60 in the name of Rhoda Grant, grouped with amendments as shown in the groupings. Rhoda Grant to move Amendment 60 and speak to all amendments in the group. Rhoda.
Thank you, Convener. I move Amendment 60 and speak to 61, 62 and 63. Amendment 61 makes it clear that abuse does not stop with breakdown of a relationship. Abusive partners will try to continue to control and abuse and use every avenue available to them to do this. And therefore abuse continues from a relationship into the arrangements being put in place for children after a relationship has broken down. Amendments 60, 61 and 63 are not introducing something new, but rather reuniting a list that was split by this bill. Scottish Women's Aid tell us that the reunification of this list is important for the protection of survivors of domestic abuse. When this list was initially introduced, it was the Parliament's intention for it to be considered as a whole to ensure adequate protection of women, children and young people who have experienced domestic abuse. It places a duty on the court to consider the wider impact of continuing abuse that can be perpetrated by enforced parental cooperation. That consideration is required for the protection of women, children and young people who have experienced domestic abuse. Children often experience abuse through the abuse of their mother, and it has a huge effect on their well-being, their resilience and their self-esteem, and in turn that can impact on their life chances going forward. The law must recognise that in cases like this, an order for parental cooperation is likely to have a hugely negative impact on a child's welfare as well as that of their mother. I see this constantly in my casework, where contact and shared parenting is used to continue to perpetrate abuse, and sometimes it has really devastating consequences. Taking the subsection, my Amendment 62, out of the context of domestic abuse does not underline to the court that this issue impacts on the safety and welfare of the child. Perpetrator of abuse could continue to use coercive control over financial issues, the health and nutrition of a child by making unrealistic demands, and all these things compromise the well-being of a child. There is a risk to the care, protection and safety of the child by the perpetrator misusing child contact or residence as a means of coercively controlling the other parent. This in turn disrupts the child's enjoyment and indeed their security of their home and family life. This is not covered by 7B or C, which is why the Parliament introduced 7D to the list, and I seek the committee's support to continue that connection today.
Thank you, Rona. Can I just confirm, did you move Amendment 60?
Yes, I move Amendment 60.
Thank you. Jeremy Balfour to speak to Amendment 45 and other amendments in the group. Jeremy.
Good morning, Convener. Good morning, Committee and Minister. Thank you for this opportunity. Can I move Amendments 45 and 46, which are in my name? I think we started this session very helpfully by putting children at the centre of what we're trying to achieve, and the child's voice to be heard where proceedings go to court. My amendments look at grandparents' rights and where grandparents fit in to contact with their grandchildren. I know the committee has taken evidence on this at stage 1, and there has been an ongoing debate over a number of years around what should happen in regard to grandparents. I believe, and the amendments state clearly, that grandparents often do have a very important role within their grandchildren's lives. They can often offer stability when a marriage or relationship is breaking down, and many offer childcare. What my amendment seeks to do is to say to the sheriff, to say to the courts, that there is a presumption that grandparents should have access to their grandchildren. However, it does not give it as an absolute right, and clearly, as we've heard already from the Minister, the child's rights should always be taken into account and should be heard by the court. But what this amendment simply does is to say to the sheriff that the presumption is that grandparents should have that right, and you are against that, you would need to give a reason for that in any judgment. Amendment 46 simply gives the definition of grandparents to leave for another time into regulations. I believe this would be a positive step forward. It recognises grandparents do have a different role compared to other relatives within a child's life, and I hope the committee will support it today. Thank you, Convener.
Thank you, Jeremy. Alec Cole-Hamilton to speak to Amendment 79 and other amendments in the group. Alec.
Thank you very much, Convener. It's a great pleasure to join you all today. Thank you for the opportunity to speak to the committee. I move Amendment 79, 81 and 82 in my name, but the remarks I'm about to make also cover Amendment 76, which is a consequential of these later on in the bill. I'm grateful to Liam MacArthur, who will move the amendments when press them for me when we get to them, because I've been called away by unavoidable business in another part of the Parliament. I'd like to start by paying tribute to Gordon and Shona Marie Mason, constituents of mine, who came to see me very soon after I was elected to tell me their story around the estrangement of their son, and by extension the estrangement from their grandson. And they have worked very hard to re-establish contact. This is not through any fault of their own, but through a coercive relationship. And so they've done a lot of work around the rights of grandchildren to maintain contact with their grandparents. I think it does them credit that that's the perspective that they chose. It would be very easy for them to try to fight for a legal right for grandparents to see their children. And they do have that to a certain degree through contact resolution through the courts. But this is more about children's rights. And they in compiling the arguments for why we need to enact these amendments into the bill, they point to the consultation firstly. The consultation of the review of the Children Act 95 showed that out of 225 children who responded to the question, 97% came out in support of grandchildren having contact with their grandparents. What they propose, and I have given voice to in my amendments 79 through 82, is very much symmetrical, or has great synergy with what the French have already done. French Civil Code Articles 371 to 4 states that the child has the right to maintain personal relationships with his ancestors. Only the interests of the child can hinder this right. So we have a right enshrined for children there, but also the best interest principle under the UNCRC exerting its preeminence. And the non-statutory charter for grandchildren in this country states that grandchildren can expect to know and maintain contact with their family, except in very exceptional circumstances and other people who are important to them, and to know that their grandparents will still love them, even if they are not able to see them at this present time. Children in this country have a right to inheritance from grandparents if their parent predeceases grandparents, but no right to have contact with them. That can have a mental health impact on children who discover the existence of grandparents. And so the intention of my amendments are severalfold. Firstly, to create a basic right to have contact with grandparents and other lineal ancestors, as it's defined in the text of my amendments, at any time, in any circumstances, in their joint lifetimes. Child should have the right, whether or not the marriage or relationship of their parents is still existing, and whether or not there is any breakup in the marriage or relationship in that relationship, whether or not the child is in care, etc. The right of the child should override any coercion by parents. I hope that's something that we should all agree on. And if the child is afforded this right by the Act, then parents could only deny it by going to court to justify why the right should not be exercised, justifiable reasons that the court will accept, and that is to say that the best interest of the child is not in the best interest of the child to have contact with their lineal ancestors. The court will not accept mere whims or bias. So fundamentally, convener, this is a right to children to access their lineal ancestors subject to their best interests. It reflects what the French have already enacted, and I think it represents international good practice. And so therefore, I move the amendments in my name.
Thank you, Alex. Liam MacArthur to speak to Amendment 83 and other amendments in the group. Liam.
Thank you, convener. I appreciate it's not so much relevant to this amendment or this grouping of amendments, but it's certainly relevant to other groupings and to the bill as a whole. So I just wanted to remind the committee of my interest, as my wife works for Relationship Scotland, Orkney, and will be taking on a director role next month. Given the time available, I'll speak simply to Amendment 83, which seeks to make equally shared parenting the starting basis for custody orders, from which courts can, of course, move towards the most appropriate split. The intention of this amendment is not to make shared parenting mandatory or to be prescriptive of any arithmetical share of time. Its intention is to tell the court to start with that option when one of the parents requests it, and then consider any reasons why a different pattern is better for the child or children involved. The general benefits for children of shared parenting are reflected in international research, whether in terms of their social and psychological well-being, educational attainment, or indeed the avoidance of adverse experiences. These benefits not only apply in the short term, but well into adulthood. I recognise, and indeed went so far as to say explicitly during the Stage 1 debate, that care should be taken to do nothing that might dilute the primacy of the best interests of the child consideration. That remains very firmly my view. However, the presumption of shared parenting need not cut across this. In countries where such a presumption already exists, the best interests of the child are no less central to the process of deciding residency and contact. It may well be that a shared parenting arrangement is neither desirable nor practical. The reasons for this could be many and varied, and the court, of course, must be left to make that decision based on the views of the child and relevant expert advice. However, given how rarely courts appear to rule in favour of an equal split in parenting responsibility, it would seem there is already a presumption inherent within the system. As society rightly expects more of a shared parenting model in relationships generally, recognise the benefits of this to the child or children involved. Why should it not be that we work from a similar starting point in the event of that relationship breaking down? And therefore I'll be moving Amendment 83. Thank you.
Thank you, Liam. We now move to contributions from members on this group of amendments, starting with Liam Kerr. Liam.
Thank you, convener. I just have a very brief question for Rhoda Grant, if I may, on your Amendment 63, please, Rhoda. The section broadly looks fine, but I just don't quite understand the motivation behind that particular amendment, and what is the practical impact of setting up a definition for one subsection? So can you just reassure me, what is this section, what's the practical impact of setting up this definition?
Rhoda.
Thank you, convener. Will I get a chance to sum up after responding to this question?
Yes, you will. You will get a chance to sum up.
Okay, thank you. Literally what I am doing is lifting what was split away from the section that is replicated in the bill. So in the bill replicated section 11, 7A and B into this bill, but left out this section. So basically what I have done is lifted the section. So it was obviously seen as important to define what a person was in the previous bill, and that has worked well. There has been no concerns with that previously. So it is basically trying not to make any change to that, a law that has worked well in the past, and bringing it forward. So that's why that definition is in, because it was in the original legislation and has worked well.
Liam Kerr, does that answer your question?
I'm very grateful. Yes, thank you, Rhoda Grant.
Right. Next person, Rona Mackay. Rona.
Thank you, Convener. I'm not going to support amendments 45 or 46 or Alec Cole-Hamilton's amendments on grandparents' rights, and for the following reasons. Of course, I agree with them that grandparents play a hugely important part in a child's life, and that bond is very special. I think we all understand that. As a grandparent, I certainly do, and every effort should be made to nurture that relationship. However, I don't believe including this presumption in the bill is correct or desirable. Circumstances surrounding family breakups are different and individual to each case, and it may not always be in the best interest of the child to have court-ordered contact with their grandparents. The child may not want to, not feel particularly close to the grandparents, and they may feel vulnerable, particularly in instances where domestic abuse has played a part in the breakup. It could cause added stress to the child involved at a particularly difficult time of their life. If the child wants contact with the grandparents, each family should be able to facilitate that without court intervention, in my view. By its very nature, the relationship or the circumstances in the case will be high conflict, and that child could be stuck in the middle of that. Also, by specifying grandparents exactly, it could exclude other adults important to the child. And the Minister has also said she'll be promoting the Grandparents' Charter heavily, and I think that's a very good thing. I look forward to that. So in essence, Convener, I won't be supporting this amendment, as I believe it fundamentally cuts across the rights of the child. On Liam MacArthur's Amendment 83 and shared parenting, I won't be supporting this because I think it could have adverse consequences to the safety of the child. Of course, it's preferable for a child to have a happy relationship with both parents where possible. In an ideal world, that's how it would always be. But putting this in the face of the bill would be unwise, I believe, and possibly dangerous for a number of children. The key points against this for me are that the majority of contact cases that end up in court concern reports of domestic abuse. Even those that don't are still likely to be cases of high conflict. All research on this matter suggests that a presumption of shared parenting in any high conflict case is likely to be harmful to the child. Being caught between warring parents is without doubt an adverse childhood experience which we would risk causing if it's included in the bill. So I believe any presumption of shared parenting being included in the bill could have harmful consequences for children and young people experiencing domestic abuse and their mothers. A presumption along these lines effectively prioritises the interests of the adults, weakening a child rights-based approach, which is entirely contrary to the meaning of this bill. Recent research showed that children and young people who experienced domestic abuse did not fare well under the discussed shared parenting arrangements or imposed contact. Dr. Sue Whitcomb has also suggested that when safeguarding concerns are raised, contact should continue while they're investigated. I believe that's a deeply dangerous approach, and there are many case histories to highlight this. Scottish Women's Aid, children's organisations are very opposed to this. Parental alienation is a term often used to mitigate allegations of domestic abuse, and it cannot be excused under any effort to justify the use of this theory, and it undermines the safety of children. So in conclusion, I believe putting shared parenting in this bill is a risk definitely not worth taking. Thank you.
Thank you, Rona. Fulton McGregor. Fulton.
Thank you, Convener, and good morning. Can I just start by saying that I offer my support to Rhoda Grant's Amendments 60, 62 and 63. But I wanted to talk about the other amendments in the group. The Grandparents Amendment, a bit like what Rona Mackay said there, I've got considerable sympathy with that. As a parent myself, I think other parents will probably agree that we have understood the true value of grandparents more than ever during this particular period. And I do actually have a lot of sympathy with the amendment in terms of recognising that special relationship between children and grandchildren. However, I do also think that it does run the risk in modern Scotland of prioritising, if you like, that particular relationship over other relationships, and I think that's something that we do need to be careful about. So I've heard the arguments both for and against that, and I think it will be interesting to hear what the Minister says in relation to the charter that Rona Mackay mentioned. And I know that the Minister talked about, at the stage 1 debate, so it'll be interesting to hear what's said there, and if it's a similar argument that's put forward as at stage 1, I would be inclined at this point not to vote for that amendment. But as I say, I'll hear how the discussion goes. In relation to the shared parent amendment, again, I've got a lot of sympathy for that, and had looked closely at that amendment myself. I think that, like Rona Mackay says, there is real issues there around the potential for domestic violence and coercive control. So I think that, again, we need to be really careful. I do think in a general sense, though, I see very much similarities between that amendment and the campaign that I've been long involved in regarding parental leave, and you know, the process to encourage more fathers to take parental leave, and it's about breaking down those gender stereotypes, that it's not just you know, a woman's job to do all the childcare work and to be the primary carer. And I actually see the resemblance of that in this this amendment. So I think it's all part of a package to move forward. It's maybe not going to be deliverable in this bill, and it's more a cultural and societal change that we need there to break down those gender stereotypes that still exist. So again, depending on how the rest of the conversation goes, particularly the Minister at this point, I think there would be too much risk to vote for this particular amendment at stage 2. I'm going to leave it at that.
Thank you. Yeah, thank you. Liam MacArthur.
Thank you, Convener. Can I start by thanking Rona Mackay and Fulton McGregor for their comments, and particularly Fulton's point there in relation to shared parental leave. I think I tried to make a linkage in my earlier comments between the expectations we have on a shared parenting model within relationships. I think Rona Mackay's absolutely right in terms of issues of high conflict, and where there's any suggestion of domestic abuse. Absolutely, the courts need to take that into consideration and act accordingly. But we cannot surely have a situation where, in a sense, there's an assumption of domestic abuse where there is a conflict and where these matters are brought before the court. There are many, many examples where, particularly fathers, find that the assumption simply is that the child is best spending a higher amount of time with the mother, and I think having a presumption, or having a presumption that we start from the basis of shared parenting, that the court, as I say, can move away from very quickly, particularly if there are any concerns around domestic abuse, seems to be a more equitable basis on which to take forward these proceedings. As I say, I entirely recognise the concerns that Rona Mackay has raised, but I think we need to move away from the situation where it is automatically assumed that where cases are brought before court, that there is somehow a risk of domestic abuse.
Thank you, Liam. No other members have indicated that they wish to speak. So can I just ask the Minister perhaps to address in her comments on these amendments how the Scottish Government is going to promote the Grandparents' Charter, which I think was an undertaking that you made in stage 1 when we discussed this bill. Minister.
Thank you, Convener. So to start, I'm very pleased to support Amendments 60, 62 and 63 in Rhoda Grant's name, subject to some minor issues being addressed before stage 3. These amendments ensure the requirement to consider the risk of abuse before making an order remains positioned in the Act, next to the requirement to consider the ability of parties to cooperate. I believe it is very important that victims of domestic abuse and their children are protected in family court cases, as has been discussed already today. And of course, this is one of the main aims of the bill. However, while I agree with the intention behind Amendment 61, I can't support that one because it would require the court to consider the need to protect the child from continuing abuse when making a Section 11 order. The court is already required to consider the need to protect a child from abuse and also from the risk of abuse. And I am in no doubt that this includes continuing abuse. And in particular, it includes an offence for an abusive course of behaviour under Section 1 of the Domestic Abuse Scotland Act of 2018. The amendment suggests that abuse generally does not include continuing abuse. So I don't agree with that. So I would hope the member would agree not to press Amendment 61. Amendments 45 and 46 in Jeremy Balfour's name and Amendments 79 and 81 in Alex Cole-Hamilton's name seek to do broadly the same things, and I do not support these amendments. I would, of course, like to assure members that I agree. I also agree with that grandparents and great-grandparents can often play a very important part in children's lives. And in my response to the Justice Committee Stage 1 report, I have committed to further promoting the Charter for Grandchildren. And I've also had a conversation in the last week or so with the stakeholders in the grandparents area. And they've also given me some very good suggestions about how we might continue to promote that. So I'll be working with those stakeholders going forward to make sure we cover as much ground as possible on that. The bill requires the court to take account of the child's important relationships with people other than their parents, and this certainly includes grandparents and great-grandparents in many cases. And of course, grandparents can also currently apply to the court for contact rights, and the decision will be made taking into account the child's views and according to the best interests of the child. And I think and believe that that is the correct position. These amendments are problematic for a number of reasons. The relationships that are important must be assessed for each child individually. One size doesn't fit all with this, and so requiring the court in every case to consider grandparents in particular could be inappropriate or it could be unnecessary. It could cause delay and also perhaps devalue other relationships. There's no explanation of how these amendments are intended to work in the current system, based on responsibilities owned by adults towards children and accompanying rights to fulfil those responsibilities. Is the court required to grant contract rights for grandparents in every case, or only where it's requested by the child? What happens if it's not requested or it's not in the child's best interests? So although these amendments are described as a child's right, I think the amendments appear to amount more to rights for grandparents. An automatic right would give grandparents greater legal rights than many other family members, including parents. And this risks the focus of the well-being of the child being lost among these competing rights of different adults. And the UNCRC avoids rights to relationships with particular family members for this very reason. So instead of ranking the importance of family members, the focus should be on the welfare of the child and the views of the child. That is the approach taken in the UNCRC, in the 95 Act and also in the bill. And unfortunately, it's not the approach taken by these amendments. So I hope for the reasons that I've put forward that members will not push these amendments further. And for similar reasons, I don't support Amendment 81 in Alex Cole-Hamilton's name. This amendment would require the court in every case to identify every linear ancestor and to assess the implications of contact and residence order on those relationships. And that applies where nothing would point towards those relationships being important to the child, where contact between the child and the grandparent doesn't exist, perhaps where it isn't wanted by either side, and where contact may not be in the best interest of the child as well. And this obviously could elongate the court process, which is unlikely to be in the child's best interest. And the amendment goes further still, instructing the court to treat relationships with lineal ancestors as important in every case. And that would be regardless of the nature of those relationships or regardless of anything the child had to say on that subject. So general rules determining what is important in every case don't allow the court to simply consider the child's best interests in the individual circumstances of each case, taking the views of the child into account. The better approach, I believe, is that in the bill, where the relationships that are important to the child must be assessed individually for each child, and not decided here by us. And as I've mentioned earlier, I recognise the important role that grandparents can play, and I am committed to further work in relation to children's contact with grandparents. However, for the reasons that I've given, I'm unable to support this amendment, and I'd ask the member not to press it. On Amendment 83, so this is in the name of Liam MacArthur, I can reassure members that in my view, both parents should be fully involved in the upbringing of their child as long as it's in the best interests of the child concerned. And parents can currently ask for residence on an equal basis, and a decision will be made where the welfare of the child is paramount, taking into account the views of the child, with full consideration given to the arguments for and against shared residence in the particular circumstances of that case. Whereas this amendment would turn that process on its head by proposing residence on an equal basis as the answer in every case before the question about the child's best interest had even been considered. So my view is that that amendment does not advance the child's interests. The amendment only refers to parents. While in most cases of this nature between parents, they don't have to be between parents, and an application for an order under Section 11 could be made by others, for example, grandparents. So the courts already apply a general principle that it will normally be beneficial for children to have an ongoing relationship with both their parents, and the bill strengthens this position by requiring the court to consider in every case the effect of an order on the involvement of the child's parents in bringing up the child. So I don't consider that this amendment is desirable, and I think that the amendment would cut across the general principles of Section 11 of the 95 Act, that the welfare of the child is of the paramount consideration. And for these reasons, I would ask the member not to press it. Thank you, Convener.
Thank you, Minister. Rhoda Grant, to wind up, press or withdraw Amendment 60. Rhoda.
Thank you, Convener. I wish to press Amendment 60. I'm grateful for the support of the Minister for Amendments 60, 62 and 63. I hear what she says about Amendment 61. I have so many parents coming to me with real concerns that the courts are being used to continue abuse. They're having to choose between contempt of court, which is of course their liberty, and the safety of their child, because there is a court order forcing them to send a child to an abusive partner. And that is continuing abuse. I listened to what the Minister has said on that, and I take her assurance, but I will. I don't think I'll move this amendment at this stage. I'll go away and consider whether or not I should be bringing it back or at stage 3, or if there is sufficient protection in what the Minister has said in her response.
Can I just clarify which one you're withdrawing, Rhoda? Or
61. 61.
Right, thank you. The question is that Amendment 60 be agreed to. Are we all agreed? If you are agreed, please stay silent. Members can indicate dissent by typing N in the chat box. No one has indicated dissent, so we are agreed. Amendment 60 is agreed. Amendment 61 in the name of Rhoda Grant, already debated with Amendment 60. Rhoda Grant, to move or not move?
Not move.
Thank you. Not moved. Amendment 62 in the name of Rhoda Grant, already debated with Amendment 60. Rhoda, to move or not move?
Move. Moved.
The question is that Amendment 62 be agreed to. Are we all agreed? If you are agreed, please stay silent. To indicate dissent, type N in the chat box. No dissent, therefore Amendment 62 is agreed. Call Amendment 45 in the name of Jeremy Balfour, already debated with Amendment 60. Jeremy Balfour, to move or not move? Jeremy?
Not move, Convener.
Not moved, thank you. Call Amendment 46 in the name of Jeremy Balfour, already debated, with Amendment 60. Jeremy, to move or not move? Jeremy?
Not moved, Convener. Not
Not
moved.
moved. Not moved. Thank you. Amendment 63 in the name of Rhoda Grant, already debated, with Amendment 60. Rhoda Grant, to move or not moved?
Moved.
Move. The question is that Amendment 63 be agreed to. Are we all agreed? If agreed, please stay silent. To indicate dissent, type N in the chat box. No one has indicated dissent, therefore Amendment 63 is agreed. Call Amendment 47 in the name of James Kelly, already debated, with Amendment 1. Can I remind members that if Amendment 47 is agreed to, I cannot call Amendment 2. James Kelly, to move or not move?
Moved, Convener.
Moved. The question is that Amendment 47 be agreed to. Are we all agreed? If you're agreed, stay silent. To indicate dissent, please type N in the chat box. We are not agreed, therefore there will be a division. Stephen.
Thank you, Convener. I'm going to just take the members through the voting procedure. So can I ask those members who are voting for the amendment, put the letter Y in the chat box now, please. Thank you. Can I ask those members who are voting against the amendment to put the letter N in the chat box now, please? Can I ask any member wishing to abstain to put A into the chat box, please? Thank you. I shall now read out the results of the vote. There were 4 members voting in favour. They were Liam Kerr, James Kelly, John Finney, and Liam MacArthur. There were 5 members voting against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Jonah Robertson, and Margaret Mitchell. There were no abstentions. I will hand over to the convener shortly, who will confirm the result of the vote.
I regret to say that I think I may have voted incorrectly, but perhaps that won't matter because my casting vote will be cast in this instance in favour, which I actually meant to do at the beginning. So for that reason, then apologies. The other thing to do is maybe just retake the vote. My apologies, I meant to vote in favour of Amendment 47. So, Stephen, can I ask you to call the vote? And that's probably the best way to do it.
Convener, could you suspend briefly while I give you a telephone call?
Yes, certainly. Right, I can now declare that the result of the vote was 4 in favour, 5 against. Therefore, that amendment is not agreed, and apologies for the confusion. Not agreed, therefore, we now move to Amendment 2 in the name of the Minister. Already debated with Amendment 1. Minister to move formally.
Formally moved, Convener.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? If agreed, stay silent. To dissent, type N in. No one has indicated dissent, therefore Amendment 2 is agreed to. Call Amendment 3 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is Amendment 3 be agreed to. Are we all agreed? To indicate dissent, type N in the chat box. No one has indicated dissent, therefore Amendment 3 is agreed to. Call Amendment 4 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
The question is that Amendment 4 be agreed to. Are we all agreed? To indicate dissent, type N in the chat box. No one has indicated dissent, therefore Amendment 4 is agreed to. Call Amendment 48 in the name of James Kelly, already debated with Amendment 1. James Kelly to move or not move?
Moved, Convener.
The question is that Amendment 48 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. No one has indicated dissent, therefore Amendment 48 is agreed. Call Amendment, sorry? Oh, sorry. Please, apologies, it's all going in now. I haven't allowed a long time. There is dissent, therefore there will be a division.
Thank you, Convener. I will take a moment and I will just run us through the vote. So, can I ask those members who are voting for the amendment to put Y in the chat box now, please? Thank you. Can I ask those members who are voting against the amendment to put the letter N in the chat box now, please? Can I ask any member wishing to abstain to put A into the chat box, please? Thank you. I shall now read out the result of the vote. 5 members voted for the amendment. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against. They were Alistair Allen, Walter McGregor, Rona Mackay, and Shona Robertson. No members abstained. I shall hand over to the convener to confirm the result.
Thank you, Stephen. 5 in favour, 4 against, then this amendment is approved. Amendment 48 is agreed. Amendment 5, I now call in the name of the Minister, already debated with Amendment 1, Minister to move formally.
Moved, Convener.
Thank you. The question is that Amendment 5 be agreed to. To dissent, please indicate by typing Y in the chat box. One minute ago. No one has indicated, is that right? I'm getting a bit confused at what I'm seeing in my chat box, if that was for the last one, I think it was. Can I confirm no one has dissented? Therefore, Amendment 5 is agreed. The question is that Section 1 be agreed to. Are we all agreed? The dissent type N in the chat box. No one has dissented, therefore Section 1 is agreed. We now move to Group 3, Disclosure of Information. I call Amendment 64 in the name of Liam MacArthur, grouped with Amendment 33 and 33A. Liam MacArthur to move Amendment 64 and speak to all amendments in the group. Liam.
Thank you very much, Convener. My Amendment 64 deals with an issue that we wrestled with quite a bit during our Stage 1 evidence gathering. It's an issue I know that a number of colleagues have taken a close interest in. I'm grateful to John Finney for adding his name to my amendment, as well as James Kelly and Liam Kerr, who both raised their own concerns during the recent one debate. As colleagues will recall, at present, intimate and highly sensitive information shared by a child with a third sector organisation can be drawn into court proceedings, even if sharing it goes against the interests of the child in question. More concerning still, there are occasions when this happens without the child even knowing. I'm grateful to Children First and Scottish Women's Aid for the work they have done, not just in highlighting the issue and providing examples of how and where this is happening, but also in helping draft this amendment in the hope of improving the situation going forward. We know that this loophole has the potential to undermine the trust and confidence of children who engage with third-party organisations. At the same time, in looking to amend the bill, we need to bear in mind the rights of others involved in any court process. Various witnesses explained robustly and fairly the risks in preventing information being shared that was relevant to any proceedings. So we need to tread carefully in balancing those various rights. I think this can be done and believe that my Amendment 64 does just that. It does so by making disclosure of such information possible, but only where it is necessary and proportionate, and the court has given consideration to the welfare and, importantly, the best interests of the child. The child should also, as far as practicable, have the opportunity to express their views about such disclosure. And I think those two latter points are the distinguishing feature between my amendment and the amendment from the Minister and Rona Mackay, which I welcome, but I don't believe go far enough. I appreciate that the Minister may have some concerns about the use of paramount in subsection 2.2. I'm certainly happy to discuss with her how this might be phrased to address those concerns. However, I believe this amendment will help strengthen the bill's ability to safeguard the best interests of the child. I look forward to hearing the views of colleagues and indeed the Minister. For now, I move Amendment 64 in my name.
Thank you, Liam. Minister to speak to Amendment 33 and other amendments in the group. Minister.
Thank you, Convener. Amendment 33, which is in my name, provides that when the court is considering making a Section 11, it has to decide whether a person should have access to information relating to a child. A court must regard the welfare of that child as primary consideration. Amendment 64, in the name of Liam MacArthur and supported by John Finney on the same issue, as is Amendment 33A by Rona Mackay. And so in some respects, I don't think the Scottish Government and Liam, John and Rona are that far apart on this issue. If Amendment 33 in my name is agreed, I will work with the members to come to an agreed position on this ahead of Stage 3 and agree any further amendments that are required. The issue here is that the court may hold sensitive information about a child. So, for example, the child at the centre of a Section 11 case may have provided views on how the case should be decided. In other instances, a party to the case may argue that a document generated out with the court case should be disclosed because the contents have a direct bearing on the case. So firstly, a child has a right to privacy, which are protected, but these cannot be absolute. It would not be possible to guarantee to a child that their views will remain confidential. Their views, for example, might turn a case, and parties to that case might expect to understand the reasons behind a decision which affects their family life. And secondly, people other than the child at the centre of a Section 11 case might have a legitimate interest in a document and whether it should be disclosed. If, for example, a document has been generated out with the court case, it might contain information about another child. And the aim of Amendment 33 is to ensure that all cases, the welfare of the child is taken into account. And Amendment 64 differs from my amendment in a couple of areas. It requires the court, in deciding whether to allow disclosure of information, to have regard to the welfare of the child as its paramount consideration. And I believe that as a matter of law, this goes too far. The word paramount has a clear meaning in the 95 Act, and it is appropriate in other contexts, but it cannot be applied to decision about disclosure of information, because to do so would not allow the court to adequately take account of the human rights of other people. And that would, of course, include other children. So one person's interests cannot be made to prevail over others in every case. So just to give the committee an example about how this would work, information provided by one child could identify the risk of abuse to a second child. Protecting that second child from abuse cannot depend entirely on whether the first child agrees to the information being used or it being used in the first child's interests. So information may also need to be disclosed because people, including children, have the right to understand the reasons behind the court decisions, because how else, of course, could they be challenged? And this is particularly important for decisions altering the parent-child relationship. And that's why my amendment makes the child's welfare a primary consideration rather than a paramount consideration. And that difference is important because a primary consideration is the wording that has been set down by the Supreme Court. Amendment 64 refers to best interests of the child as well as welfare, and this appears to be a duplication. And I don't consider that the word chosen here to be a major issue. I do prefer welfare because that is the language that is generally used in the 95 Act and it is understood well. But more important is that the issue cannot be determined according to the best interests of one person alone. Amendment 64 only protects the child at the centre of the Section 11 proceedings. It provides no protection to any other child whose information is used, such as a sibling. So by contrast, my Amendment 33 would protect children more widely. Amendment 64 also refers to obtaining the child's views on whether the information should be disclosed. And I have two concerns on that. The first point is practical. The child may have already expressed views when providing their information to the court about how, for example, the case should be decided. And we should, of course, wish to avoid the child being asked the same question twice. And the second point is that others may have legitimate interest in some documents, and the court may need to ask them for views as well as asking the child. And so I think that it is then best to leave the detail of how children are consulted to the rules of court in this case. On Amendment 33A, I do recognise the need to consult the child in appropriate cases, but this also should be dealt with through the rules of court. So more fundamentally, the court must be able to balance the rights of all the people affected. The issue cannot be determined purely by consent or interest of just one person, and we would need to ensure that any amendment in this area strikes that appropriate balance of rights. If Amendment 33 in my name is agreed, I will work with key stakeholders on preparing a policy paper on the rule changes for the Family Law Committee of the Scottish Civil Justice Council. And I move Amendment 33. Thank you, Convener.
Thank you, Minister. Rona Mackay to speak to Amendment 33A and other amendments in the group. Rona.
Thank you, Convener. Yes, I lodged this amendment because during evidence we did hear a very moving account. I think it was a youngster's diary that had been shared around officials without her knowledge, and the distress that she suffered was terrible, as you can imagine. So I really wanted to highlight what can happen when the best interests of the child are overlooked or disregarded. However, I'm not going to move this amendment because I've since thought of the unintended consequences this could have in individual cases, such as causing delays and having the lack of necessary information for the correct decision to be made. And it may also put extra pressure on the child when they're feeling at their most vulnerable. I'm also content that the Minister's amendment will protect children more widely, and it will prevent unnecessary sharing and promote court awareness, which has often been previously lacking around this matter. So I'm happy to support the Minister's amendment. Amendment 64, Liam MacArthur's and John Finney's supporting this amendment. I'm not supporting it because, although I think it's very well intentioned, I do agree with the principles of it. The reasons I'm not supporting it are very similar to the reasons I'm not moving my own. I think the government amendment covers this without placing restrictions in court procedure and the unintended consequences for the child which could result in it. And I believe there's also a policy paper for the Family Law Committee of the Scottish Civil Justice Council being produced, and the government is committed to working with Children First and Scottish Women's Aid in this regard, which I'm pleased about. Guidance and information sharing and confidentiality for everyone involved in the court procedure has been proposed, which could be done in advance. So for these reasons, I'm not going to be supporting this amendment, as I'm perfectly content with the Minister's amendment.
Thank you, Rona. Now move to comments from members. John Finney.
Thank you very much indeed, Convener. And can I thank my colleague, first and foremost, Liam MacArthur, for submitting this amendment. He was quicker off the mark than me, and I think what we've heard throughout this debate, and I hear exactly what the Minister says, is I don't think there is a dispute from anyone as to the intentions of where we all want to go with this. It's important that decisions made about the most vulnerable people often are informed decisions, and these informed decisions will require the disclosure of information on occasions. It is about the access to that information, and hearing all that's been said, I certainly took reassurance from subparagraph 2, subparagraph 2B1, where there's a specific reference there to the competing rights and how one will weigh up against the other. Indeed, it says the likely benefit to the welfare of a child arising in consequence of disclosing the information outweighs any likely adverse effect on any other person arising from disclosure. And as is often the case with rights, there are competing rights, and privacy is important. And Rona Mackay alluded to some of the evidence that we took in camera from young people, and the very compelling and harrowing story of the young girl whose diary was disclosed to someone who most certainly wouldn't wish information shared with. I hear what the Minister says about all cases and individual cases there, and I think this in some respects is an issue that we all wrestle with in our daily working as well, and that is the confidentiality we perhaps might have with constituents, which applies except if there are adverse effects for other people or it was disclosing a crime. I hear a lot of consensus in this, and clearly it would be a matter for colleague Liam MacArthur to decide. I think what we all want to do is get the best possible outcome here to ensure that there is informed decision making, and I hope that there would be continuing discussions. As I say, I don't hear any conflict of us wanting to get to take place. Thank you very much indeed.
Thank you, John. Liam Kerr.
Thank you, Convener. Just to reiterate, I think John Finney made a good point there. I mean, I'm certainly in a place where I think the Minister's amendment is a good one, but I'm also minded to support Amendment 64 in Liam MacArthur's name if he chooses to press it. The main reason I come in here, Liam MacArthur knows from our committee sessions and the Stage 1 debate that I was concerned about this exact area, as I think we all were. And I was very glad when he decided to bring this amendment forward. But Liam MacArthur also knows that I found the evidence that the Minister alluded to actually about the rights of others in this pretty persuasive and as important as I'm sure the rest of the committee did. So what would be really helpful is if Mr MacArthur, in summing up, if he can reassure me that just around the balance, like he did in his opening statement, but just give me a bit more that the balance has been struck by this. And furthermore, given that the Minister sets up a legal argument in favour of her wording, which members know that I enjoy immensely listening to those sorts of arguments, can Liam MacArthur tell me his specific response to that legal argument and whether he's got any legal advice that would tend to persuade me towards his wording rather than the Minister's?
Thank you, Liam. No other members have indicated they want to speak, so can I just comment that for me there's a fundamental issue of trust here, and the trust of the young person being potentially betrayed. And I think that came through loud and clear when the committee heard evidence from the young people themselves. Confidentiality should be proportionate, obviously, but to abuse that confidentiality in the example Rona Mackay quoted, where old diary was handed over, really is something that must be avoided at all costs. So I would be minded to support Liam MacArthur's amendment, but I look forward to his wind up, and whether Liam MacArthur, whether you're going to press or withdraw Amendment 64. Liam.
Thank you, Convener. I'm minded actually to clip John Finney's contribution earlier, share it with all those I've played football with over the years, who will be astonished to hear that I am somehow quicker off the mark. But I'm very grateful to John for his support. As I acknowledged before, this is an issue I think a number of us we're looking to see addressed at stage 2. I'm grateful to Rona, Liam Kerr and yourself, Convener, for their contributions to the discussion, as well as the Minister, who I think was right in saying that we're not very far apart in this in terms of the amendments. I think addressing Liam Kerr's specific point on the legalities, I'm tempted to adopt the approach of ministers to say I clearly cannot share with him any legal advice, but what I can do perhaps is quote from Children First and Scottish Women's Aid's briefing on this specific point, because Liam Kerr's absolutely right. This was a real concern that those of us who wanted to see the bill amended needed to square away. And what Children's First and Scottish Women's Aid say is this amendment will not prevent information from being shared where it is proportionate and relevant to the court. Indeed, our organisation strongly believes that proportionate and relevant information sharing is in a child's best interest to keep them safe and ensure the courts are equipped with all the details at their disposal to make informed decisions. I think in terms of distinguishing between the amendments, I listened carefully to what the Minister had to say and appreciate that Rona Mackay shares some of the concerns she expressed. But again, Children's First and Scottish Women's Aid have suggested that the amendment in my name, Amendment 64, is indeed stronger, and it's stronger precisely because, and again I'm quoting from their briefing, it includes specific reference to best interests of the child in line with UNCRC, as well as ensuring the children's views are taken into account when decisions are made about sharing their information. I think for those two reasons, I would urge the committee to support my amendment instead of the government's amendment. I absolutely acknowledge the concern the Minister has made in relation to the use of the word paramount, although paramountcy does appear within the bill itself, and therefore it would at least appear consistent with that. But taking on board her concern around paramount, I'm happy if the committee support Amendment 64 to work with the Minister and officials ahead of stage 3 to tidy up any concerns, address any concerns that she has. But for the time being, I move Amendment 64 in my name.
Thank you. The question is Amendment 64 be agreed to. Are we all agreed if you're agreed, please stay silent. To indicate dissent, please type N in the chat box. Yeah. We are not agreed, therefore there will be a division. Stephen.
Thank you, Convener. So can I ask members who are voting for the amendment to put the letter Y into the chat box now, please? Thank you. Can I ask those members who are voting against the amendment, put the letter N into the chat box now, please? Can I ask any member wishing to abstain to put the letter A into the chat box now, please? Thank you. I shall now read out the results of the vote. 5 members voted for the amendment. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against the amendment. They were Alistair Allen, Fulton McGregor, Rona Mackay, and Shona Robertson, and no member abstained. And I shall pass over to the convener to confirm the result of the vote.
Thank you. 5 members voted in favour, 4 against. Amendment 64 is therefore agreed. Call Amendment 6 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister.
Moved.
Thank you. The question is that Amendment 6 be agreed to. Are we all agreed? If agreed, stay silent. To indicate dissent, type N in the chat box. There's no indication of dissent, therefore Amendment 6 is agreed. Call Amendment 49 in the name of James Kelly, already debated with Amendment 1. James Kelly, to move or not move? James.
Moved, convener.
Thank you. The question is that Amendment 49 be agreed to. Are we all agreed? If agreed, stay silent. To indicate dissent, please type N in the dissent box. We are not agreed. There will be a division. Stephen.
Thank you, convener. So on Amendment 49, can I ask those members who are voting for the amendment put the letter Y into the chat box now, please?
Hold on a minute.
Thank you. Can I ask those members who are voting against the amendment to put the letter N into the chat box now, please? Can I ask any member wishing to abstain to put the letter A into the chat box, please? I shall now read out the result of the vote. 5 members voted for. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson. no members abstained, and I shall pass over to the convener to confirm the vote.
Thank you. The result is 5 in favour, 4 against. Amendment 49 is agreed. Call Amendment 7 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister.
Moved formally.
Thank you. The question is that Amendment 7 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. There has been no indication of dissent, therefore Amendment 7 is agreed to. Call Amendment 8 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister?
Moved.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. There's no indication of dissent, therefore Amendment 8 is agreed. Call Amendment 50 in the name of James Kelly, already debated with Amendment 1. James Kelly, to move or not move. James.
Moved, convener.
Moved. The question is Amendment 50 be agreed to. Are we all agreed? To indicate dissent, type N in the chat box. We are not all agreed. There will be a division. Stephen.
Thank you, convener. Thank you, convener. Can I ask those members who are voting for the amendment to put the letter Y in the chat box now, please? Thank you. Can I ask those members who are voting against the amendment to put the letter N into the chat box now, please? Can I ask any member wishing to abstain to put the letter A into the chat box? We'll now read out the result of the vote. 5 members voted for. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robison. No members abstained. I shall pass over to the convener to confirm the vote.
Thank you. 5 members voted in favour, 4 against. Amendment 50 is agreed. Call Amendment 9 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister?
Moved, convener.
Thank you. The question is that Amendment 9 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. No member has indicated dissent, therefore Amendment 9 is agreed to. The question is that Section 2 be agreed to. Are we all agreed? We are all agreed. Call Amendment 51 in the name of James Kelly, already debated with Amendment 1. James, to move or not move?
Moved, convener.
Moved. The question is that Amendment 50 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. We are not agreed. There will be a division. Stephen.
Thank you. I shall now take members through the vote for Amendment 51. So can I ask those members who are voting for the amendment to put Y into the chat box now, please? Can I ask those members who are voting against the amendment to put the letter N into the chat box, please? Can I ask any member wishing to abstain to put the letter A into the chat box, please? And I shall now read out the result of the vote. 5 members voted for the amendment. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, Liam MacArthur. 4 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay and Shona Robertson. No members abstained, and shall pass over to the convener to confirm the vote.
Thank you. 5 members voted in favour, 4 against. Therefore, Amendment 51 is agreed. Call Amendment 10 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister?
Moved.
Thank you. Question is that Amendment 10 be agreed. Are we all agreed? To indicate dissent, please type N in the chat box. No one has indicated dissent, therefore Amendment 10 is agreed. The question is that Section 3 be agreed. Are we all agreed? We are all agreed. Now move to Group 4, Vulnerable Witnesses, Relevant Offences and Special Measures, until Amendment 11 in the name of the Minister, grouped with Amendments 12, 13 and 14. Minister to move Amendment 11 and speak to all amendments in the group. Minister.
Thank you. So Amendments 11, 12, 13 and 14 strengthen the provision which Section 4 of the bill makes on the prohibition of personal conduct of a case. One of the aims of the bill was to further protect victims of abuse and domestic abuse in family court cases and children's hearings, and the prohibition of personal conduct of a case in the bill is one of the key provisions for this. The bill creates a presumption that a party who is convicted or prosecuted for committing certain offences against a witness should not be able to conduct the case themselves. So Amendments 11, 12 and 13 expand on the offences which trigger that protection. At the moment, the list of offences includes sexual offences, domestic abuse offences and other serious violent offences. And these are the same offences that trigger the prohibition on personal conduct in the criminal context. The amendments strengthen the provision by adding the following offences. Firstly, an offence of female genital mutilation as set out in Section 1.1 and 3.1 of the Prohibition of Female Genital Mutilation Scotland Act 2005. Secondly, an offence of stalking as set out under Section 39 of the Criminal Justice and Licensing Scotland Act 2010. And thirdly, forced marriage offences under Section 122 of the Antisocial Behaviour, Crime and Policing Scotland Act 2014. The last offence will include a forced civil partnership if the Civil Partnership Scotland Bill is enacted. In many cases, the offences that I've mentioned would already be covered if there is an accompanying domestic abuse aggravation, or the witness may already be protected as a child witness. Also, where the presumption does not apply, the court still has broad discretion to authorise the prohibition of personal conduct where it is the most appropriate way to hear the evidence of a vulnerable witness. However, I am keen to ensure that in all cases where a party has committed the offences mentioned above against a witness, there is a presumption in favour of prohibition of personal conduct of a case. Amendment 14 aims to ensure that in children's hearings, court proceedings, where there is a child witness, that then there would be a mandatory prohibition on personal conduct of the case by a party. The bill inserts a new special measure into the Vulnerable Witnesses Scotland Act of 2004, Section 12(1)(b) of this Act provides that the court may make an order that a child witness is to give evidence without the benefit of any special measure. The bill requires the court that if there is a child witness to assume that the prohibition of personal conduct of a case is the most appropriate special measure. And this amendment will mean that in all children's hearings court proceedings, if a child is attending as a vulnerable witness, then there will be mandatory prohibition on personal conduct of the case by a party. And I move Amendment 11. Convener, thank you.
Thank you, Minister. No member has indicated that they wish to comment. Therefore, the question is Amendment 11 be agreed. Are we all agreed to indicate dissent? Please type N in the chat box. No member has indicated dissent. Therefore, Amendment 11 is agreed. Call Amendments 12, 13 and 14 all in the name of the Minister and previous debated, and invite the Minister to move Amendments 12 to 14 on block.
Moved on block.
Yeah, thank you. Does any member object to a single question being put on Amendments 12 to 14? No member has objected. The question is therefore that Amendments 12 to 14 are agreed. Are we all agreed? To indicate dissent, put N in the chat box. No one has indicated dissent, therefore Amendments 12 to 14 are agreed. The question is that Section 4 be agreed. Are we all agreed? We are all agreed. The question is that Sections 5 to 7 are agreed. Are we all agreed? And again, you can put N in the chat box if you want to indicate dissent. No one has done so. Therefore, Sections 5 to 7 are agreed. We now move to Group 5, Child Welfare Reporters, Qualifications and Experience. And I call Amendment 65 in the name of Liam MacArthur, grouped with Amendments 66 and 67. Liam MacArthur to move Amendments 65 and speak to all amendments in the group. Liam.
Thank you very much, Convener. Amendment 65 would ensure that, as in other parts of the UK, the role of the child welfare reporter is carried out by appropriately qualified and registered social workers. As we heard during evidence at stage 1, in 90% of cases, this role is currently performed by lawyers. Yet, were we constructing a system from first principles with the intention of putting the welfare of the child at the centre of the process, we honestly say we would envisage lawyers taking on such a key role. If the welfare of the child is paramount, we must begin with the obvious question: is the child at risk of harm? This is not simply about living arrangements or rules around contact time. Compiling reports often requires assessment of child protection, development, and mental health. But while social workers are trained, qualified, and statutorily regulated in matters of child welfare and risk, lawyers are not, nor indeed do they have an associated professional duty to report risk. As the committee heard, there are many lawyers who have built up a wealth of experience in this area, and I have no doubt they provide a good service to those they are supporting. Certainly in the gathering of evidence and an understanding of the court process, they will be more than adequately skilled. But the assessment of a child's welfare is complex and requires different skills. Dr. Whitcomb and Dr. Child have noted that other professionals working with children are required to undertake several years of training. Children First and Scottish Women Aid also suggest that 4 days training, which is what the financial memorandum makes allowance for, is insufficient. I know the Minister has expressed concerns in the past about the capacity of qualified social workers to take on this role and the potential for increased delays. On the former, it's important to stress this is not just about council social work departments. And Dr. Whitcomb has set out figures that suggest there would be ample capacity across the sector in Scotland. As for delays, while currently cases involving more specialist input can take longer, this is a reflection of complexity. The evidence from elsewhere in the UK rebuts any notion of delay, quite the reverse. We need to acknowledge that there are professionals that already have the training that child welfare reporters need. and already work within a regulatory regime that develops and maintains the right skill set. I look forward to hearing the comments from the Minister and other colleagues, but urge members to support Amendment 65, which I have pleasure in moving. Thank you, Convener.
Thank you, Liam. Neil Finlay to speak to Amendment 66 and other amendments in the group. Neil.
Thank you very much, Convener, and I welcome the opportunity to speak to the committee this morning. First of all, I would like to pay tribute to my former constituent, Emma MacDonald, who took forward her petition to the Petitions Committee, and I know that petition was very powerful, and I don't think we would be where we are today in relation to contact centres had that not happened. In terms of the amendments, it's very important that the person writing welfare reports knows the child and the circumstances that the child has experienced, so that they can write reports in an informed way. It's not acceptable for people to write reports if they don't know, haven't met, or barely know the child involved. This should be done by trained professionals with appropriate training and qualifications. It's also very important that if we want to change something, then we really need to establish what is wrong with the system in the first place. And speaking to those who have experienced the worst of the system can offer a way forward and show how far we have to go to make improvements. We have to consider it from the perspective of the people involved in the system, particularly the children and the parents involved. Children often offer a real clarity of what is going on, and that can be overlooked and dismissed because of their age and inexperience. But children are, as we know, very perceptive. They know what and who they like and what and who they don't, and they know who or what scares them and upsets them. And it's essential that children and adults who have experience of domestic abuse and the court-ordered contact are involved at all stages of drawing up regulations to ensure that the current system is made as user-friendly and as child-friendly as possible for all who use it. And it's not a system that continues to persecute or punish parents or cause fear and alarm to those who use contact centres. So I think we all agree that the child should be at the centre of the system, and I think these two amendments absolutely follow that principle.
Thank you, Neil. The following members have indicated they wish to speak: Fulton, Rona and John. Fulton.
Thanks, Convener. This would seem an appropriate point to make my declaration of interest for just now's amendment and for the rest of the session as a registered social worker. And I suppose then it's no surprise that I've got quite significant sympathy with this amendment, and had also looked at it myself when Dr Whitcomb was in touch with committee. And I agree that the overall principle behind it and the direction that the government are going in with this, and I will be interested to hear what the Minister says. I think if we were starting from scratch, if this bill was addressing an area that was not already covered, this is exactly what we would do. But I think there's two major issues that we didn't take enough evidence on, and would give me some concerns at the moment. The first is the impact on social work services. I know that Liam MacArthur addressed this a bit, but I can tell people from personal experience that these reports are not easy bits of work. I think you would expect that to be the case. They can involve several visits, they can involve hours of phone calls, and they can involve hours of follow-up. So I really think that we would need to be taking that into account. And I do think that, while we might believe that it could be spread across the board, I think a lot of it would fall on to local authority social workers to undertake. So while I'm not against the idea by any means, I do think that we do need to consider the impact, and as the government have already outlined, this could then end up having an unintended consequence and not in the interests of the child across other areas of social work, and including the reports themselves. And also, I think the second area is we would need to have more understanding of the impact that this would have on the legal profession. What impact would it maybe have on jobs within the legal profession, and what exactly are the skills that lawyers bring to the table in this particular field, because I think it's unfair to say that no lawyers are particularly skilled in this area. And again, from my own experience, I can say that I had really good working relationships with a lot of lawyers who were very much child-centred. So again, we would need to have a wee bit more understanding about that. As I say, I do agree with the general principle. That won't come as a surprise to anyone. I do think, though, I will be interested to hear what the Minister's saying about the direction we're perhaps moving in. And while not inclined to vote for it today, it'll be interesting to see how this can be brought back at stage 3 a bit more worked out. Thanks, Convener.
Thank you, Fulton. Rhona, then John. Rhona.
Thank you, Convener. Yeah, just briefly, really to agree with Fulton in many ways there, and I have sympathy with these amendments, great sympathy, but I think Amendment 65 is just a bit too narrow. I think, it sort of, what about psychologists and other people with skills and experience who could be trained and who could do the job? Yes, I mean, lawyers are primarily doing it just now. It would undoubtedly mean, it'd be detrimental to them, but that wouldn't be my primary concern. But I just think it's too narrow, and it would stop other professionals who, could have a good skill in this area from coming forward. And some social workers, aren't really trained in dealing with young people and engaging with children anyway. They may be more focused on the older age group. So for that reason, I wouldn't support it. Neil Finlay's huge sympathy with this, and I agree with Neil in many aspects, and I have concerns around contact centres. I've expressed these, but again, I think his amendments are a bit too vague and a bit too restrictive, and I'm confident that the bill that we're putting forward, and especially when it gets to stage 3, will address the issues in relation to this in terms of welfare reports, etc. And I hope it's tightened up to do that, but I can't support the amendments here today.
Thank you, Rhona. John Finney.
Thank you, Convener. Thank you, Convener. Yes, I said at the outset I've supported my colleague Neil Finlay's amendment. I think he's outlined the rationale for them very well. Excuse me. As regards Liam MacArthur's amendment, I won't be supporting that. I think it approaches things from entirely the wrong way. We need to be looking very, very clinically and systematically at things like post and person specifications, a skills profile. And it seems to me that undoubtedly there's a requirement of an understanding of child protection issues that would seem to be absolutely fundamental. Likewise, the benefits of understanding child development. But I'm concerned that we would lose a measure of expertise, not just from with the legal profession, but also the potential to harness much of the expertise that exists in the third sector about this. I mean, we know from the committee's visit and looking at things like the Barnhouse model, it's about the skills, it's not about the designation of the profession of the individual involved. So for those reasons, I won't be supporting 65, but will also be supporting 66.
Thank you, John. No other member has indicated the wish to contribute. Can I just say in relation to Amendment 66, I totally appreciate the sentiment and the motivation behind this, but I do have concerns about the vagueness in the provision, and look forward to the Minister's comments on this. And in terms of Amendment 66, it does appear to be overly restrictive, but again, I'd be interested to hear the Minister's contribution. Minister.
Thank you, Convener. So the Scottish Government doesn't support the amendments in this group. Section 8 of the bill establishes a register of child welfare reporters, and individuals would be eligible to apply to be on the register if they meet the relevant requirements in relation to training and qualifications. And that training and qualifications will be set down in regulations, and there'll be a full public consultation on the requirements, which will be developed with the welfare of the child at the heart of those proceedings in mind. So Amendment 65 from Liam MacArthur would only allow social workers to be child welfare reporters. I understand where the member's coming from with this. At the moment, around 90% of child welfare reporters are lawyers, but I'm not convinced that there's a justification here for losing that pool of expertise by just limiting that role to social workers. So in my view, the most important factor for a child welfare reporter is that they meet their required standards, regardless of their professional background. And I know Liam MacArthur attempted to address this point about capacity, but I'm not clear whether there is sufficient capacity in the social work sector to take this role on. There may be, but we don't know that for certain at this point. And I think that would require further detailed consideration on that. And we couldn't obviously get to a situation where we just didn't have enough capacity in order to undertake the reports that need to be undertaken, because obviously that would put us in a very bad situation. I am very keen to encourage non-lawyers to become child welfare reporters, because I do think that a diversity of experience in this role of a child welfare reporter would be very beneficial to the process. I think a number of members made good points around this, and Rona Mackay and also John Finney and Fulton McGregor. What we're looking for, and I think this sums up a bit what they were saying, is what we're looking for is people who have the right skills, the right experience and the right expertise, not necessarily a job title. So these people might be social workers, they may indeed be social workers, but equally they could be child psychologists, or they may well be lawyers. And so I've set out in my response to the Justice Committee in advance of stage 2 about how I plan to encourage social workers to apply to be child welfare reporters. And I hope for these reasons that the member will not press his Amendment 65. So moving on now to Neil Finlay's amendment, which is 66. I have to say that when I first looked at this amendment, I wasn't entirely clear on what the amendment was intended to do. If a person has the requisite skills and experience to be included on the register, then they could apply to be included on the register. That's what the section already says. So I'm not entirely clear how the person's professional knowledge of a particular child is relevant to the question of whether the person can be on the register generally. I do take the member's point that a professional person might have already worked with a certain child and maybe be in a good position to write a child welfare report. But Section 8 is not dealing with who will write a report in relation to a specific child. It's obviously much wider than that. So I'm happy to discuss this further with Neil Finlay before stage 3 to ensure that I've understood what his concerns are around this. But I would ask him not to press that amendment today. On Amendment 67, I do see the point that the member is making with this one. And of course, when drafting regulations, we need to ensure that people with lived experience give us their views. And I agree that people who have experienced court order contact and people that have experienced domestic abuse have got valuable insights to give us. So I assure the member that we will obtain views from people in these categories, as I have done throughout the development of the bill process, which has been over the last couple of years. And we'll do that either through formal consultation processes, or by meetings, or by discussions, or by both.
Thank you. Neil Finlay, I believe you've got a question for the Minister. Neil.
Thanks, Convener. Yeah, in the discussions that we had, Liam Kerr was party to those discussions on the phone regarding the bill. The Minister said that any system that was being established would take 3 years to set up. Is that still the case? Because that seems an extraordinary length of time to bring forward regulations and set up the system. I think to the recent past, we were told we could set up a new state in 18 months, and yet we can't set up this system in 3 years.
Minister?
Yes, so the timeline for the projection of when different parts of this will be undertaken has already been set out to the committee. I did undertake to Neil Finlay that I would ask officials to look again at that timeline to see if there was any possibility of it moving quicker. But I think the member and indeed the committee would also have to accept that at the moment, with the situation with the health pandemic that we're in and COVID-19, we've had to move staff around in various directorates, and they've been taken over to work in the health department. So I wouldn't be confident about it being able to be delivered quicker, but I have made that undertaking that I will ask officials to look at everything and see if there is a possibility that we could do it faster.
Neil Finlay, content?
Not content at all.
I appreciate that. Right, Liam MacArthur, to wind up, press or withdraw Amendment 65. Liam.
Thank you, Convener. Thank you for your comments, and to Rona, Fulton, John, and of course the Minister for their contributions on Amendment 65. I think it's probably worth reminding the committee that up until changes in legislation in 1984, it was social workers that predominantly carried out these welfare reports. I appreciate the issue around capacity. I think Fulton in particular obviously speaks with a degree of insight into this issue. As I say, Dr Whitcomb is certainly very clear that those capacity issues shouldn't be a problem, whether or not indeed it's drawing on people who are no longer active in practice, who put themselves forward as welfare reporters. There does appear to be a wider pool from which to draw, and as I say, it's not simply about council social work departments themselves shouldering this responsibility. I think, understand the anxieties that colleagues have expressed in terms of limiting this solely to social workers. As I tried to say in my opening remarks, I'm not trying to call into question the skills that lawyers bring to bear in this area, and some of them have become very specialist in this field indeed. But a 90% rate at which lawyers are carrying out these roles does seem to me to be excessively high, and that actually the complexity in terms of putting together welfare reports, the judgments, the assessments that need to be made are likely to fall far more readily into the sorts of skill sets, the training, and indeed the regulation that social workers have. I think what I'll maybe do, Convener, is reflect on the concerns that have been raised, specifically the one around maybe being overly restrictive through the course of this amendment, and look to bring back something at stage 3 that takes maybe into consideration the concerns that have been raised. So I think for the time being, I will not move Amendment 65.
So, Liam MacArthur is seeking permission to withdraw Amendment 65. Does any member object? If you do, please type N in the chat box. No member objects, therefore Amendment 65 is withdrawn. Call Amendment 66 in the name of Neil Findlay, already debated with Amendment 65. Neil Findlay, to move or not move? Neil?
Moved, Convener.
Moved. The question is therefore that Amendment 66 be agreed to. Are we all agreed? If you all agreed, stay silent. To indicate dissent, type N in the chat box. We are not all agreed. There will be a division. Stephen.
Thank you, Convener. So I'll now start the process for the vote on Amendment 66 in the name of Neil Findlay. Can I ask those members who are voting for the amendment to put the letter Y into the chat box now, please? Thank you. Can I ask those members who are voting against the amendment put the letter N into the chat box now, please? Can I ask any member wishing to abstain to put the letter A into the chat box now, please? I'll now read out the result of the vote. 3 members voted for the amendment. There were James Kelly, John Finney, and Liam MacArthur. 6 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, Liam Kerr, Margaret Mitchell, and I shall hand over to the convener to confirm the result of the vote.
Thank you. 3 members voted in favour, 6 against. Amendment 66 is not agreed. Call Amendment 67 in the name of Neil Findlay, already debated with Amendment 65. Neil Findlay to move or not move. Neil?
Moved.
Thank you. The question is that Amendment 67 be agreed to. Are we all agreed? To indicate dissent, type N in the chat box. Members have indicated that they are not content, therefore there will be a division. Stephen.
Thank you, convener. So, Amendment 67 in the name of Neil Findlay. Can I ask those members who are voting for the amendment to put the letter Y in the chat box now, please? Can I ask those members who are voting against the amendment to put the letter N into the chat box now, please? Can I ask any member wishing to abstain to put the letter A into the chat box now, please? I shall now read out the result of the vote. 3 members voted for the amendment. They were James Kelly, John Finney, and Liam MacArthur. 6 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, Liam Kerr, and Margaret Mitchell. And I shall hand over to the convener to announce the results.
Thank you. 3 members in favour, 6 against. Amendment 67 is not agreed. The question is Section 8 be agreed. Are we all agreed? We are all agreed. Section 8 is agreed. We now move to Group 6, responsibility of contact centres, called Amendment 68 in the name of Neil Findlay, grouped with Amendment 69. Can I point out if Amendment 15 to be debated in the next group on regulation of contact services is agreed to, I cannot call Amendment 69 in this group. Neil Findlay to move Amendment 68 and speak to both amendments in the group. Neil.
Thanks, convener. Contact centres currently do not assume responsibility for children on their premises. The responsibility for that always lies with the parent. So it begs the question, how can it be reasonable or indeed safe for that responsibility to lie with a parent who themselves is subject to supervision? It's my view that those who run the contact centre and their staff must be responsible for the child's safety at all times whilst there. This must be a condition of a child being on the premises of a contact centre. If a court requires a child to attend a contact centre, then the staff and the company who run it, or the organisation who run it, must take responsibility. My former constituent who brought the initial petition on contact centres was told that they couldn't guarantee her safety or that of her children whilst on the premises, and that they were not responsible for them, as the parent who was subject to supervision, a supervision order, was there. That does not make any sense and appears to be a way of passing the buck on liability should something happen. These amendments would make the contact centre staff and the company or organisation who run them responsible for the health, safety and well-being of any child on the premises.
Thank you, Neil. Neil, can I just check that you did actually move Amendment 68?
Sorry, I move both amendments. Thanks.
Thank you. No Other members who have indicated they wish to speak. John Finney.
Thank you very much, Convener. Thank you, Convener. It's a question for Mr. Finlay, please. And I wonder, Neil, can you outline how that squares with the obligation that every property owner would have for having regard to the welfare of people on their premises, not least because you would imagine that their approach and their liabilities would have had to be underpinned by a risk assessment anyway. Can you talk about the relationship there, please?
Neil Finlay?
Well, I think Mr. Finney raises a very good point, but it's certainly not the experience of Emma MacDonald that was the case when she raised very serious concerns about her children being left in the premises where they couldn't ensure that the child was safe, and where there were very obvious risks to the child. For example, there was no CCTV on the premises. There was a very low window that it was open at a height that a child could easily have climbed out and fallen from. These issues were raised with the person running the contact centre and the company running the contact centre, and yet they were told that the safety and well-being of the child is the responsibility of the parent. And again, as I mentioned earlier, that parent could be themselves subject to, or very often is subject to supervision for particular reasons. In this case, it was a domestic violence case, and that raised very serious concerns in itself. So I think Mr. Finney raised a very pertinent point.
Okay. John, content?
Thank you.
No, thank you. No other member has indicated they wish to speak. Can I say in the face of it, it seems an entirely reasonable amendment, but I'd be interested in the Minister's comments. Minister.
Thank you, Convener. So I want to ensure that all cases of contact at a contact centre are facilitated safely and appropriately as well. And that's why Section 9 of the Bill gives Scottish Ministers powers to set minimum standards for contact centres in the regulations. So I cannot support Amendment 68 and 69, and I would actually urge members to vote against them if Mr. Finlay chooses to press them, because it's entirely unclear what the nature of the responsibilities that they seek to impose on the contact centres is. So are they dealing with responsibility as a matter of the law of delict? Contact centres already have liability for instance on their premises under the normal mechanism of law, which is I think the point that John Finney was making. And it's also not clear what the intended effect of the amendments would be on those with parental rights and responsibilities in relationship to a child. So these amendments contain quite vague and unspecified legal duties. I would urge Mr. Finlay not to press these amendments today, but I would like to make the offer to Mr. Finlay that if he wants to discuss this further with a view to bringing them back at stage 3, I would be happy to work with him so that he's able to do that.
Neil Finlay, to wind up, press or withdraw Amendment 68. Neil.
I would normally press the amendment, but the Minister's made the offer, and I will engage with a view to, if we don't make progress on that, bringing the amendment back at stage 3. And if I maybe could just at this point say on the record, Convener, that I will await the Minister's office making contact for us to have that discussion.
Thank you. Are members content for Amendment 68 to be withdrawn? No dissent has been indicated, and therefore Amendment 68 is withdrawn. The question is that that is withdrawn. Right. I think at this point it would be an opportune time to have a comfort break, so I suspend for 5 minutes. We now move to Group 7 amendments, and I call Amendment 15 in the name of the Minister, grouped with amendments as shown in the groupings. Can I point out that if Amendment 15 is agreed to, I cannot call Amendment 69, already debated in the previous group, or Amendments 52 and 53 in this group. Minister to move Amendment 15 and speak to all amendments in the group. Minister.
Thank you, Convener. So I recognise the important role that's played by child contact centres, and I want to ensure that in all cases that contact that takes place there is safe and appropriate for children. So Section 9 of the Bill gives Ministers the power to set by regulations minimum standards for contact service providers, which they must meet and they must continue to meet in order to be registered as a provider who's entitled to take court referrals. The point has been raised with the government that because a provider can operate multiple centres, deregistering the provider for failing to meet the minimum standards at one centre may be a disproportionate response. If the other centres are operating well, there's no reason that their work should be interrupted. So these amendments address the point by providing for individual contact centres as well as service providers be registered so that if there's a problem with an individual centre, it can be deregistered without affecting the work of any other centre operated by the same provider. Of course, if the problems encountered in one centre allude to a problem endemic to everything a particular provider does, the option of deregistering the provider entirely, that is still available. I understand that in order to facilitate contact for families in remote areas, there may be no permanent contact centre. Rural service providers use alternative premises on an ad hoc basis, and in this context, requiring the registration of premises would not be practicable. The amendments therefore also allow for regulations to set down circumstances in which a provider may use unregistered premises, subject to those premises still meeting the minimum standards that will be laid down in the regulations. And there will be a full public consultation on the detail of the standards as the secondary legislation is developed. So I move Amendment 15. On Amendments 52 and 53, and these are in the name of James Kelly, would require that all referrals to a contact centre will be to a regulated centre. And this would include solicitors who are referring clients, social workers and other agencies who are referring families, and also individuals who are self-referring. And the bill currently provides that court-ordered contact must take place at a contact centre operated by a regulated contact service provider. But I would expect that once regulations are in place for court referrals, solicitors and others would recognise in practice and refer families to a regulated contact centre. However, the concerns raised at stage 1 and the committee's recommendation that the Scottish Government should amend the bill at stage 2 so that referrals to contact centres from solicitors and from others must be made to a regulated centre. So I'm not inclined to introduce mandatory measures which might impose a duty or require enforcement measures if this is unnecessary. But for that reason, I made a commitment in the Family Justice and Modernisation Strategy to discuss with the Law Society of Scotland and the Faculty of Advocates whether guidance could be issued to encourage solicitors to refer clients to regulated contact centres. However, in light of concerns raised by my officials, we're now engaging with the Law Society to consider whether we can go further in relation to solicitor referrals and whether a legislative duty could work in practice. And if our conclusion is that such a duty would be workable, I'll bring forward amendments to that effect at stage 3, and I would be willing to work with the member on this. In terms of referrals made to contact centres from other persons, including individual parents who self-refer, I still have a concern about how a duty or a mandatory provision in that area would actually work out in practical terms. But given the commitment that I have made to look at further solicitor referrals in advance of stage 3, I'd ask the member not to press that amendment. Amendment 70 would require contact centre regulations to include provision for staff to be trained and to hold recognised professional qualifications in relation to issues concerning children. And I agree that staff who work in contact centres should have the right professional qualifications. And the bill already provides an appropriate mechanism for addressing staff training and qualifications in regulations. So I don't think that this amendment is necessary. I also think the amendment is framed, or the way that the amendment is framed, it could place an undue burden on services by requiring them to ensure that all their staff and their volunteers have these professional qualifications, irrespective of their individual roles. So there may be some staff that perhaps work in reception and so on and don't have direct contact with the children. So I'd be happy to discuss staff training and qualifications further with the member as the regulations are developed. But I can't support this amendment and I'd ask the member not to press it. Amendment 71 would require contact centre regulations to make provision about access to and facilities at contact centres for disabled children. And I can assure Bob Doris that I fully recognise the seriousness of this issue. I want to ensure that all children have access to contact centre service and that all contact is facilitated safely. So the bill already provides a mechanism for addressing issues around accommodation and also around staff training, and addressing this by regulation. It allows us that time to consider in more detail what standards are required and how to undertake a full assessment of the existing laws on issues such as disability access. So in this instance, we need to ensure we don't cut across or duplicate existing provision, and there may also be implications for the law on equal opportunities, which also require some detailed considerations. So we're going to explore these issues fully as part of the process for developing the regulations. There's obviously going to be a full public consultation on the draft regulations next year. I give my commitment to the member that on the issue of disabled access, that will be considered as part of the consultation, and I am happy to discuss this further with him at any time. And we'll also ensure that the consultation includes disability organisations and the Equality and Human Rights Commission. So in short, I understand the members' concerns on that. I understand the intentions behind the amendment, but I can't support the amendment at this point for the reasons I've given, and so I would ask the member not to press that amendment. Amendment 72. If it's okay, Convener, I've just got a couple more amendments that I'd like to touch on.
Yeah.
Amendment 72, which is the name of Neil Finlay, that adds a function for the body appointed to oversee the contact centre regulation to undertake risk assessments, and for these to be carried out by staff trained in undertaking such assessments. But I would expect that the body that's appointed to oversee contact centres will undertake risk assessments as part of the inspection process, and I would also expect the persons carrying out those risk assessments to have the necessary training. So the functions of the regulatory body will be set out in regulation, and I'll work with the Care Inspectorate to consider the matters that they've set out in the feasibility study report as those regulations are developed. I think I understand the intention behind this amendment, but I don't think it's necessary for the reasons that I've just set out, and I would ask the member not to press that one. On Amendment 73, I do agree with Neil Finlay that we need to ensure people with relevant lived experience give us their views when we consult. Throughout this bill, I have done that, and I intend to continue to do that. So I would ask the member not to press Amendment 73. Amendment 74 would require regulated contact centres to be publicly provided and accountable to Scottish ministers. I'm not exactly clear on what that amendment is supposed to cover, and I do have some concerns that this could exclude, say, third sector organisations, public sector bodies, private sector bodies, or even local authorities. So if the intention behind it is to address the concerns that were raised at stage one, and that was including by the committee around the longer term funding of contact centres, then I would say that I have lodged an amendment that allows Scottish ministers to enter into arrangements for provision of contact services, and this would pave the way for Scottish ministers to let a contract for contact services and ensure that the contact services are funded on a secure and sustainable footing. And for the reasons stated, I can't support that amendment, and so I'd ask the member not to press that one. Thank you, Convener.
Yep. James Kelly to speak to Amendment 52 and other amendments in the group. James.
Thank you, Convener. I speak to Amendments 52 and 53 in my name. The committee had substantial evidence about the conditions at contact centres and real concerns that children were being placed in a situation where they weren't safe because of the conditions, and also because of the lack of training of those who were working in the contact centres. And this also come up in the stage one debate. So if we are serious about ensuring that the child is properly safe in these situations, then we need strong regulation in this bill to ensure that is achieved. From that point of view, my amendments 52 and 53 seeks to ensure that where a referral is made to a contact centre, that contact centre should be a regulated contact centre by a recognised service provider. I know the Minister's comments in terms of the caution of making these elements mandatory. However, I think that if we're to take on board the evidence that we heard and the comments at the stage 1 debate, then we need a mandatory aspect to this, and that would ensure the safety of the child. It would give parents confidence who are bringing their children to the contact centres, and it would address the shortcomings that we've heard. I believe that amendments 52, 53, in combination with Neil Finlay's amendments 70, 72, 73 and 74, would provide a stronger network around contact centres, which would give a greater primacy to the safety of the child and greater confidence for parents taking their children to these centres. And with that, I move amendments 52 and 53 in my name.
Thank you, James. You do that later, but move to Neil Finlay to speak to Amendment 70 and other amendments in the group. Neil.
Thank you, Convener. When dealing with vulnerable children, it must be in the child's best interest to surround them with people who are competent, knowledgeable, professionally qualified, and who are able to understand and react to a child's response to any particular situation and record it based on their professional experience and knowledge. Without such training and qualifications, you have well-meaning individuals, often volunteers, who do not know how best to respond to different situations and behaviours that may arise in contact centres. If you're not basing your observations on training and qualifications and experiences in a role, then what are decisions being based on? This needs to be urgently dealt with. No volunteer without the appropriate qualification or training and or relevant experience should be involved with vulnerable children in such a situation. And court reports often come from notes that were taken at the time by unqualified volunteers, collated into a report by someone else working for the organisation at a later date. This surely becomes open to interpretation and mistakes. So Amendment 70 seeks to remedy this situation by ensuring staff are trained and hold recognised professional qualifications. I think that the Minister puts forward a red herring when she says that other staff, for example, I would give this example, the plumber unblocking the toilet would need to be qualified in issues relating to children if they were working at the contact centre. That's just simply not the case. In terms of Amendment 72, it must be best practice to employ the services of someone suitably qualified in risk assessment to assess the danger to children or other adults, including staff, on the premises. Some of the people attending contact centres may have serious criminal conviction, could be for violence or domestic abuse. Given the inherent risk that some individuals may bring to a situation involving children, then it is best practice for someone with specific risk assessment qualifications and knowledge of the criminal justice system, of domestic abuse and coercion and control, to make such a risk assessment. This process is currently done by contact centre staff, again, whereas the qualifications and professional knowledge that informs such decision making. On 73, lived experience, it is essential that we include people with lived experience as they bring a unique perspective to the situation, and that has to be, they have to be listened to prior to implementing any regulations. If I take example of my former constituent, her son's lived experience of contact centres was that they were places they were forced to go against their will, where the staff wouldn't listen to them and coax them into seeing someone they didn't want to see. They were scared, and there was a physical change in their behaviour, as noted by their school. They felt physically sick before going and would struggle and would undress so as not to leave the house on days when contact took place. That is the real lived experience that we should be listening to. On Amendment 74, if the state, via the court, requires a safe environment for children to attend a contact centre, then this has to be a service that retains public confidence. Children must come first, not finance, so it's my view that such a system should be publicly run and publicly accountable. We see what happens and what's happened in the asylum system, where organisations like Serco and Capita have won tenders for providing services, and these services do not retain public confidence, and they have actually been pretty disastrous. So we're reforming the current system of contact centres, which is already a tendered system, because of the failings within the system, and yet we want to repeat that failure by putting such a service out to tender again. This amendment is based on practicality but also accountability, and when we were first raising the issues of contact centres, trying to find out who was accountable for them, who overseen them, and who we could get answers to about their practices was a very difficult thing indeed. So a publicly run, publicly accountable service has to be the way to go in such a vital area of children's welfare. And this is not just about funding, it's about the whole ethos underpinning the system. And we're only at this stage because of the failings of the existing system. So this amendment, this final amendment, would provide a robust foundation that people can have confidence in. And I hope members will support all the amendments that I've put forward.
Thank you, Neil. Bob Doris to speak to Amendment 71 and other amendments in the group. Bob.
Thank you, Convener. In speaking to Amendment 71, I want to briefly outline the situation my constituents found themselves in. They have a teenage son with cerebral palsy. Around 2 years ago, they were awarded supervised contact to see their son by a court. However, the contact centre did not have a suitable adapted disabled toilet. Over a number of months, adaptations were made. Subsequently, a hoist was said to be deemed to be required and funding was secured for that. After that, it was decided that a suitable changing mat wasn't available. This does sound bizarre, so one of those had to be purchased. Then, just as they thought contact would go ahead, they thought it was imminent, they were advised that there would have to be staff identified and trained and funded to operate the hoist. Now, thankfully at this stage, and I spoke to my constituent yesterday, this now appears to have been secured. They're hopeful they will see their son soon post-lockdown. But this is 2 years since the initial contact was awarded by a court. Now, I raised the matter of disabled children at contact centres during the Stage 1 debate. I have also corresponded with the Minister on the matter, and I welcome their comments today, as well as having raised the matter at First Minister's questions. Indeed, I also raised the matter with the contact centre itself on several occasions, and with Glasgow Sheriff Principal and the Lord Advocate, in the hope that the court system would ensure that where contact was awarded by a court, that a young person had a disability, that any contact centre was suitably adapted. None of these representations bore any fruit or success. The current situation is surely a scandal. This amendment can start to address that scandal. By placing the requirement for contact centres to be made to make relevant adjustments necessary for a disabled child to access a contact centre and use the facilities, including toilets, on the face of this legislation, can hopefully drive the required change, and quickly. The amendment also states that relevant adjustments means, in relation to a disabled child, alterations or additions which are likely to avoid a substantial disadvantage to which the disabled child is put in using the contact centre in comparison with children who are not disabled. That is surely the right thing to do. And in using the expression relevant adjustments and substantial disadvantage, I have sought to give legal consistency, as this is the language used in the 2010 Equality Act. Likewise, the definition of a disabled child means a child with a disability within the meaning of Section 6 of the Equality Act 2010. Again, offering consistency and certainty. Now, Convener, I know the Minister would wish this matter to be dealt with in guidance, and indeed the details around the delivery of ensuring adequate disabled access can be placed in guidance. Of course it can. However, guidance can be ignored or it can be open to interpretation. Placing these disability requirements on the face of the bill would give any subsequent guidance real teeth. I would have concern that without this in the face of the bill, little may change for disabled children and for non-resident parents. Their rights could be enshrined within this bill. And I did listen carefully, Convener, to the reassurances given by the Minister when she was speaking to the various amendments. Those were substantial and welcome, but I have to know the direct connection between those reassurances and what will eventually end up in guidance. In terms of issues about crossover in relation to minimum standards for accommodation and training and other things that are going on, I suspect there would be a little overlap there, given the fact from what I can see currently, these simply do not exist. So I welcome the reassurances given. I need to know that in consulting on the guidance, that it is a bottom line for the Scottish Government that that guidance will have enshrined within it mandatory and enforceable guarantees in relation to disability access to buildings for training of staff to use items such as hoists and the like, so that my constituent or other constituents out there simply don't wait 2 years to see their child. That's unacceptable. Now, I'll wait to hear what the Minister says, but I want to work with the Minister to get the reassurances I desire and would rather work in partnership with the Government.
Thank you. Another member has indicated they want to contribute. So, Minister, to wind up.
Thank you, Convener. Thank you. So, in terms of James Kelly's amendments regarding the non-court referrals, I mean, I do agree very much with the member regarding the intention of what his amendments are seeking to achieve. But I am exploring how this can be done. Obviously, the Law Society of Scotland are consulting their practitioners and so on, so we're looking into this at the moment. It's not entirely straightforward, and it's the enforcement part that needs to be worked out in some detail. I'm sure the committee would agree that there's no point in enacting something into law if it cannot be enforced. So I am exploring that issue, and I do agree with the intention behind the amendments. Neil Findlay, I honestly feel that Neil Findlay's many of his points are already addressed by the bill, because the ability to set training standards for the staff of contact centres and then regulate them. And that's why I am seeking to regulate contact centres, because obviously they were not currently regulated. I'm seeking to regulate them in order to make sure that they do meet certain standards, standards which will be fully consulted upon publicly. For Bob Doris, there's some consideration that needs to be taken in terms of the legal situation around the amendments that he's suggesting. So we need to consider them further. It may be that contact centres are already required to make reasonable adjustments for disabled persons to access their facilities under the Public Sector Equality Duty in the Equality Act of 2010. And making provision on this could relate to a reserved matter and equal opportunity. So we just need to make some further legal considerations on that. And so I would ask the member to work with me on this whilst I take the time to take some further legal advice on this. And he is obviously can then bring his amendments back at stage 3.
Thank you, Minister. The question is Amendment 15 be agreed to. Are we all agreed? If you agree to stay silent, to indicate dissent, please type N in the chat box. There is dissent, therefore we now move to divisions. Stephen.
Thank you, Convener. So we are voting on amendment. We're voting on amendment 15. Okay.
Yeah.
So
amendment 15.
can I ask those members who are voting for the amendment to put Y into the chat box now, please? Can I ask those members who are voting against the amendment to put N in the chat box now, please? And can I ask any member wishing to abstain to put the letter A into the chat box now, please? Thank you. I now announce the results of the vote. 7 members voted for. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, Liam Kerr, John Finney, and Liam MacArthur. 1 member voted against. That was James Kelly. There were no abstentions. I shall pass over to the convener to confirm the results of the vote.
Thank you. 7 in favour, 1 against. Therefore, Amendment 15 is agreed. So in that case, we now move to Amendment 16. Amendment 16 is the name of the Minister, already debated with Amendment 15. Minister to move formally. Minister.
Moved.
Thank you. The question is that Amendment 16 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. No member has indicated dissent, therefore Amendment 16 is agreed to. Call Amendment 17 in the name of the Minister, already debated with Amendment 15. Minister to move formally. Minister?
Moved formally.
Thank you. The question is that Amendment 17 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. There have been no indications of dissent, therefore Amendment 17 is agreed to. Call Amendment 70 in the name of Neil Finlay, already debated with Amendment 15. Neil Finlay, to move or not move. Neil?
Move.
Thank you. The question is that Amendment 70 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. We are not agreed. There will be a division. Stephen.
Thank you, convener. So on Amendment 70, can I ask those members who are voting for the amendment, please put Y into the chat box now, please. And can I ask those members who are voting against the amendment, please put N into the chat box now, please.
Oh, I see mine's not going in. Pardon.
I shall take a second, Margaret, for you to vote.
Yeah, I didn't realise it wasn't recording, sorry.
Bear with me, just want to check the results there. And can I ask any member wishing to abstain to put A into the chat box now, please? And I shall read out the results of the vote for Amendment 70. 2 members voted for. They were James Kelly and John Finney. 7 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, Liam Kerr, Margaret Mitchell, and Liam MacArthur. And I hand over to the convener to confirm the result.
Amendment 70, there were 2 votes in favour and 7 votes against. Therefore, Amendment 70 is not agreed to. Right. We now move to Amendments 18, 19, 20 and 21, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 18 to 21 on block. Minister?
All moved on block, convener.
Thank you. Does any member object to a single question being put on amendments 18 to 21? If so, please type N in the chat box. No person objects, and therefore the question is that amendments 18 to 21 are agreed to. Are we all agreed? No one has indicated dissent, so we are all agreed, and amendments 18 to 21 are agreed. Amendment 71, I now call in the name of Bob Doris, already debated with Amendment 15. Bob, to move or not move? Bob.
Convener, during the Minister's summing up, I lost internet connectivity, so I wasn't absolutely clear on the reassurances given. Now, I think when the Minister was addressing my amendment, Ash Denham promised to look at the matter again and try and give legal certainty in how this might interact with the reserved aspects of the Equalities Act, and we might return to this at stage 3 and she would take the views of her officials. So I could be wrong in that. That was certainly in relation to one of the amendments, but the internet connectivity was lost. So I wanted to put that on the record before I say that at this point I will not move my amendment, but I will hold my position for stage 3.
I wonder, Minister, can you give Mr. Doris that assurance?
I can,
Minister?
yes, he summarised quite well what I said. I am looking at this issue, but I need a little more time to look into the legal implications of it.
That's great. So that amendment is not moved. The question, therefore, is that we move to Amendment 70. We move to Amendment 22 in the name of the Minister, already debated with Amendment 15. Minister, to move formally.
Moved.
Thank you. And the question is Amendment 22 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. There have been no indications of dissent, therefore Amendment 22 is agreed to. Call Amendment 72 in the name of Neil Finlay, already debated with Amendment 50. Neil Finlay, to move or not move?
Move.
Neil. Thank you. Now, that Amendment 72 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. And there is dissent, so there will be a division. Stephen.
Thank you. Thank you, Convener. So this is a vote on Amendment 72. Can I ask those members who are voting for the amendment to put Y in the chat box now, please?
Hold on. Yeah, hold on.
I shall wait a second for everyone to vote. Can I ask those members who are voting against the amendment to put N into the chat box now, please? And can I ask any member wishing to abstain to put A into the chat box now, please? And I shall now read out the result of the vote. 5 members voted for the amendment. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against: Alistair Allen, Bulletin McGregor, Rona Mackay, and Shona Robertson. And there were no abstentions. And I'll hand over to the convener to confirm the result of the vote.
Amendment 72, 5 in favour, 4 against, which means Amendment 72 is agreed to. Call Amendment 23, 24 and 25 on the name of the Minister and all previously debated, and invite the Minister to move Amendments 23 to 25 on block. Minister?
Moved on block.
Thank you. Does any member object to a single question being put on Amendments 23 to 25? If so, please indicate by putting N in the chat box. No member has indicated objection. Therefore, the question is that Amendments 23 to 25 are agreed. Are we all agreed? Again, if you're not agreed, please indicate with N in the chat box. No one has indicated they disagree. Therefore, Amendments 23 to 25 are all agreed. Call Amendment 73 in the name of Neil Findlay, already debated, with Amendment 15, Neil Findlay, to move or not move. Neil?
I'm on a roll here, Convener. Yes, move it, please.
Thank you. Question is that Amendment 73 be agreed to. Are we all agreed to indicate dissent? Please type N in the chat box. There is dissent, therefore there will be a division. Stephen.
Thank you, Convener. For Amendment 73. Can I ask those members who are voting for the amendment put Y in the chat box now, please? And I ask those members who are voting against the amendment to put N into the chat box now, please. And I ask any member wishing to abstain to put A into the chat box now, please. And I shall now read out the result of the vote. 3 members voted for the amendment. They were James Kelly, John Finney, and Liam MacArthur. 6 members voted against. They were Alistair Allen, Walter McGregor, Rona Mackay, Jonah Robertson, Liam Kerr, and Margaret Mitchell. And I shall hand over, no members abstained. I shall hand over to the convener to announce the results.
3 in favour, 6 again. Amendment 73 is not agreed to. I now call Amendments 26, 27 and 28 on the name of the Minister and all previously debated, and invite the Minister to move Amendments 26 to 28 on block. Minister.
Moved on block.
Thank you. Does any member object to a single question being put? No one has indicated objection. Therefore, the question is Amendments 26 to 28 are agreed to. Are we all agreed? If you disagree, please put N in the chat box. No one has indicated disagreement. Therefore, Amendments 26 to 28 are agreed. Now call Amendment 74 in the name of Neil Findlay, already debated, with Amendment 15, Neil to move or not move. Neil?
Moved.
Moved. The question is that Amendment 74 be agreed to. Are we all agreed to indicate dissent? Please put N in the chat box. And we are not all agreed, therefore there will be a division, and Stephen to call the vote. Stephen.
Thank you, convener. So on Amendment 74, can I ask those members who are voting for the amendment to put Y into the chat box now, please? and ask those members who are voting against the amendment to put N into the chat box, please. And ask any member wishing to abstain to put A into the chat box, please. And shall read out the result of the vote. 2 members voted for. They were James Kelly and John Finney. 7 members voted against. They were Alistair Allen, Walter McGregor, Rona Mackay, Jonah Robertson, Liam Kerr, Margaret Mitchell and Liam MacArthur. And I'll hand over to Convener to confirm the result of the vote.
On Amendment 73, 2 members voted in favour and 7 members against. Is that correct, Stephen?
That's correct. On Amendment 74, 2 voted in favour and 7 against, and there were no abstentions.
Thank you. That means that Amendment 74 is not agreed. Call Amendment 20. We now move to Group 8. These are minor and technical amendments, and I call Amendment 29 in the name of the Minister, grouped with amendments as shown in the grouping. Minister to move Amendment 29 and speak to all amendments in the group. Minister.
Thank you. The amendments in this group, which are in my name, make minor adjustments to ensure consistency of expression across the statute book. I don't propose to take up the members' time by going through each amendment, but if anyone has any questions, I'd be happy to answer to those, and I move Amendment 29.
I don't have an indication for any members wishing to speak. So, Minister, I presume you do not wish to wind up? Content. Okay, the question is that Amendment 29 be agreed to. To indicate dissent, please type N in the chat box. No one has indicated dissent, therefore Amendment 29 is agreed to. The question is that Section 9 be agreed to. Are we all agreed? We are all agreed. Now move to Group 9, Arrangements for Contact Centres, and call Amendment 30 in the name of the Minister and a group of its own. Minister to move and speak to Amendment 30. Minister.
Thank you, Convener. So Amendment 30 paves the way for the Scottish Government to contract for contact services across Scotland. And of course, I recognise the important role played by contact centre services. And I want to ensure that the funding of contact services is put onto a secure and also a sustainable footing. So I've carefully considered the concerns that were raised by the stakeholders and MSPs at Stage 1, and also the comments made by the committee in its Stage 1 report about the funding of contact centres. And I consider the most effective way to meet the objective of securing long-term funding for contact services would be to carry out a tendering exercise for the provision of child contact centre services through an open and transparent competition process. And Amendment 30 paves the way for that, and I move Amendment 30.
Okay, thank you, Minister. Liam Kerr, I wonder, do you want to ask any question of the Minister?
No, I don't. Thank you, Convener. My point in the chat box was something separate. I mean, since you brought me in, this was one of the sections of Amendment 30 that I was interested in, and I've listened to what the Minister has to say, and unless I hear different, I'd be inclined to be voting for the amendment.
Okay, no other members have indicated they wish to speak. Minister, is there anything you wish to say in wind up?
to pass on the winding up.
Okay, thank you. Question is Amendment 30 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. No one has indicated dissent, therefore Amendment 30 is agreed to. We now move to Group 10, renaming residence and contact orders, and call Amendment 75 in the name of Fulton McGregor in a group on its own. Fulton McGregor to move and speak to Amendment 75. Fulton.
Thank you, Convener. Thanks, Convener. This amendment seeks to address an area that members will recall was subject to substantial discussion throughout Stage 1, the renaming of the terms residence and contact. I feel that there is a broad agreement that how we word things is important and the impact it can have on the practice of professionals and those working in the sector. And I'm grateful for the Minister and the organisations that have submitted briefings and have acknowledged the intention behind this amendment. As the Minister is aware, I am happy to say from the outset that this is a probing amendment, and I'll be interested to hear what she and other members have to contribute to the overall debate. I have not made alternative suggestions to these terms because it is probing and because I do not think that is for me as one person to do. I think that there should be a collaborative approach between young people, organisations and practitioners about what terms might work best for Scotland. But I do know that in England and Wales, for example, the terms were replaced relatively recently simply child arrangement orders, and I believe that that is working pardon me, pretty well at the moment. I'm also aware that the Family Justice Review recommended using the same term, child arrangement orders, and which would set out arrangements for the upbringing of the child when court determination of disputes related to the care of children is required. As I said, I'm grateful for the input from other organisations, and I think that there is broad agreement. I could quote from the Children and Young Person Commissioner briefing to members. We agree that the terms contact and residence are not child friendly and do not necessarily reflect modern living arrangements. However, this amendment does not present any alternatives. We would welcome continued discussion on this out with consideration of the current bill. The Women's Aid and Children's First joint briefing to committee, I'll quote that here. Our organisations have often shared concerns about language and terminology used by the courts when speaking about children and the relationships that they have with the important people in their lives. While we recognise the limitations of the existing terminology, this amendment does not appear to offer a viable alternative, and it goes on to say that there should be further consultation undertaken on more appropriate terminology. So I do feel that there is a general consensus on this issue and that these terms are not considered optimal, but there is a debate over what they should be. I fully agree with that, and that's why I'm happy for this to be a probing amendment, as I say, to further air the issue and hopefully come back with a more agreeable solution before Stage 3, whether that needs to be on the face of the bill or not. I'm quite open-minded about. This could include the setting up of some group or forum to discuss the best options and include the organisations that I have mentioned. And I know also from my own practice that these are not terms that are deemed acceptable to our young people, and I think we need to listen to them as well. It may be that one of the arguments against any change may be that they are reasonably well understood by practitioners, but this bill is about young people and children, and I really feel that they should be involved in any discussions going forward. At the end of the day, practitioners will adapt to new terminology. This is nothing new. New legislation, new guidance is presented all the time, but misplaced words at the wrong time could have a much greater impact on a child going through difficult circumstances. So I think that has to be the key consideration here. I do look forward to the discussion. As I've said throughout this mini presentation, I'm not expecting to press the amendment at this stage for the main reason that I have not offered any alternative wording, and I've given my reasons for that. Thank you, Convener.
Thank you, Fulton. No member has indicated that they wish to speak, so Minister, your comments, please.
Thank you, Peter. On Amendment 75, I appreciate the point that's raised by Shared Parenting Scotland about the use of the terms contact or residence could wrongly imply that one parent has a closer relationship with the child or more decision-making powers than the other parent, but I'm not able to support the amendments for a number of reasons. So first of which is that the term contact and residence, they have been in use for some time and they have gradually gained acceptance and they are widely understood. The terms can be seen as a useful descriptor of the types of order that can be made under Section 11 of the 95 Act. And the amendment doesn't seek to remove all references to contact from Section 11 of the 95 Act. And there are a range of different orders that the court can make under Section 11. So a Section 11 order might have nothing to do with contact between children and their parents or a child's residence. So the term Section 11 order doesn't really tell anyone what that order would be about. And I would also say that continued use of the terms would seem to be likely in any event. I still receive correspondence relating to the terms custody and access, as I'm sure many MSPs do. These terms were actually replaced in the 95 Act. I have committed to producing guidance to parties on what it's like to go to court, and I would be willing to include text in this guidance to emphasise that these terms do not mean that one parent has a closer relationship with the child, and I hope that that would go some way to addressing the members' concerns.
Thank you, Minister. Fulton McGregor, to wind up, press or withdraw Amendment 75.
Thanks, Convener, and thanks to for her comments. I think that the point about the terminology still being used from previous legislation is actually one of the points that I'm trying to make. There is no doubt that the terminology would still continue to be used by people who have referred to it for already a long time. But I think that's the point. We need to start somewhere. We need to start changing the mindset somewhere. And certainly, for example, the words custody are much less used now than they were 10 years ago and 20 years ago, to use an example. So I don't completely agree that that's a reason for not changing something. But I do accept the point that a lot of it needs to be done in practice rather than in law. And I think that individual organisations, councils and third sector organisations do need to have a look at what their young people, what the needs of their young people are, and if the terms can be changed at a practice level. So I do accept that point. I just wonder if, Convener, if I could ask the Minister a quick question. Given the amount of briefings that we've received on this, and everybody seems to be saying the same thing, that the terminology isn't great. However, it would require further discussion. Is the Minister open to a further discussion about this ahead of stage 3, and perhaps how we would involve young people in the discussion about what terms we use?
Minister?
Ask that question, yeah. Is that right? Okay, thanks.
Yes, I would be open to discussing with the member ahead of stage 3 about, and if the member has other terms that he would like us to consider for an amendment. But at the moment, I'm content. I think that the terms that are in use are not meant to be pejorative. They're just meant to be a descriptor. They are well understood in practice. And I would possibly have some concerns about changing it and that people wouldn't perhaps understand the new terms for some years to come. But I would be happy to meet with the member again to discuss this further.
Fulton?
Okay, thanks, Convener. And based on that response, I'm not to press the amendment just now and have a further discussion ahead of stage 3. I know that several other members on the committee have also expressed a keen interest in this area, and I would politely ask if they would also not consider pressing the amendment at this stage just now as well. Thank you.
Okay, are members content for Amendment 75 to be withdrawn? If you're not, please put N in the type box. If not, no member has indicated that they disagree with that, therefore Amendment 75 is withdrawn. Right. We now move to Group 11, Promotion of Contact Between Child and Others, and I call Amendment 54 in the name of the Minister, grouped with Amendments 76, 77, 55, 78 and 31. Minister to move Amendment 54 and speak to all amendments in the group. Minister.
Thank you, Convener. On Amendment 54, the committee recommended that the word practicable be removed in their Stage 1 report, and Section 10 highlights the importance that this government places on the need to promote relationships between siblings for children requiring care away from home. Removing the word practicable from the bill removes the concern that had been raised that practicalities could be inappropriately used to prevent contact from happening. Amendment 55 removes unnecessary wording to ensure that the focus is on those that the child might not otherwise have contact with. On Amendment 76 and 78, I fully understand that a child's continued link with key people from their childhood can be very beneficial to them. In relation to Mr. Cole-Hamilton's amendment, lineal ancestors, I feel is quite an unclear expression, and it could involve a large number of people, which is not in the best interest of children, and it could also create a disproportionate burden on local authorities. The Scottish Government recognises the important role grandparents play in the lives of many young people, and as we've already discussed earlier in this session, I am committed to further promoting the Charter for grandchildren. I have much admiration as well for the role that foster carers play in the lives of many care experienced young people. However, the breadth of people that can be part of a child's life cannot be covered by Amendment 78, and so I cannot support it. Firstly, the aim of our policy is to focus on the needs of the child and not on the adults who may come into contact with them. And just over a third of Scotland's looked after population is in foster care. And whilst many foster placements do offer long-term stability for a young person, some offer shorter solutions. And in relation to former foster carers, this amendment makes no distinction then between different types of care that a young person may experience. So to impose a duty on local authorities to promote contact with all foster carers could be disproportionate and would not serve the best interests of children, as it would take resources and focus away from the child's core relationships. Secondly, I am supportive of efforts to sustain contact with those who have had a positive impact on a child's life, but I would expect local authorities already to be assessing the needs of a child in their care and making decisions about who they stay in touch with on an individual basis, led by the child and led by the child's views. Many local authorities, for example, involved in family group conferences and programmes such as Lifelong Links centre around the needs of the young person by building relationships and long-term social connections with family members as well as other family, other adults and former foster carers. The Scottish Government will be taking forward work on updating the guidance for looked after children, and input from the fostering network and others would of course be beneficial, ensuring that the crucial role that foster carers play is adequately reflected. So I'd ask the member not to press amendments 76 and 78. On amendment number 77, the language used in section 10 to define siblings, I understand the concerns that the member has raised here, and I offer to engage with Rhoda Mackay to explore an appropriate replacement of those terms and bring forward an amendment that can meet that at stage 3. And so at the moment, I can't support Amendment 77. Amendment 31, one of the asks in the Stand Up for Siblings, Pledge for Siblings, is to introduce a duty on children's hearings to consider contact between the child and their siblings, and this amendment does just that. It also requires that the hearing to specifically consider contact with the child's relevant persons, and this will most often be a parent. And panel members across the country daily make considered legal decisions for children, and they are best placed, in addition to their decisions as to where a child stays, to consider the contact that a child should have with their parent and their siblings. And they could also decide to make a measure of no contact, of course, if this was in the child's best interest, for example, in the case of an abusive parent. This amendment allows a bespoke approach to be taken in the relationship between siblings at children's hearings, and that is in line with the decision of the Supreme Court just last week in the case of A, B, C and XY. These cases, as the committee is no doubt aware, considered siblings' participative rights in children's hearings, and the court decision recognises that the legislative scheme behind Scotland's children's hearings is compatible with children's Article 8 rights. But as we have previously indicated, ministers want Scotland's care system to move from compliance and into excellence, and it remains our ambition to bring in procedural and practical improvements to better serve our children in care and to maintain relationships with their brothers and sisters. And so my intention is to bring any necessary amendments at stage 3 of the Children's Scotland Bill to address any further gaps that may be apparent. And this will also enable the government to honour our independent care review promise on siblings. And I move Amendment 54, Convener.
Thank you, Minister. Amendment 76 is in the name of Alec Cole-Hamilton, and as he indicated before when he spoke, then Liam MacArthur will be speaking to and moving or not moving any amendments in Alec Cole-Hamilton's name. Liam MacArthur, therefore, to speak to Amendment 76. Liam.
Thank you, Convener. Obviously, I have an amendment in my own name in this grouping as well. Just to be clear, do you want me to speak to that amendment at this stage, or
just on Amendment 76, and I'll call you separately, Liam, for your own amendment?
That's fine, Convener. I think suffice to say, and given the pressures of time, given that Alex Cole-Hamilton isn't planning to move the amendments based on the debate on the earlier substantive amendments, I don't think there's really much to add here, and I won't be moving the amendment as requested by Alex Cole-Hamilton.
Right, thank you, Liam. Rona Mackay to speak to Amendment 77 and other amendments in the group. Rona.
Thank you, Convener. Yes, I can be brief here. The terminology whole blood and half blood just struck me as being incredibly archaic, and it just had a real Harry Potter ring about it. And I just couldn't see how it could still have a place in 21st century legislation, and I'd like the words biological and non-biological to replace it. However, I won't move this amendment. The Minister has said she will enter into discussion about this at stage 3 to ensure compatibility, which would have a consistent approach in both UK and domestic legislation, and I'm content with that. I haven't changed my view on the language, but I'm content to enter into discussion for stage 3. I won't debate Fulton's amendment because I think he encapsulated everything that he needed to say in that. Thank you.
Thank you, Rona. Liam MacArthur to speak to Amendment 70 and other amendments in the group. Liam.
Thanks again, Convener. Can I start by acknowledging the support of Jeremy Balfour and Fulton McGregor for Amendment 78. I'm also indebted to the Fostering Network for their advice and support in framing the proposed change to the bill. As the Fostering Network remind us in their briefing, foster care allows children to develop valuable relationships. Keeping in touch with the people they love and trust is important for children and young people as they move through or even out of the care system. Sadly, for many of the relationships they have developed with their foster carers are not prioritised or supported. In some cases, children and foster carers are even prevented from maintaining contact due to an outdated belief that children must break their attachments in order to make new ones. Abruptly ending relationships is damaging, can be damaging to children who can then be left feeling abandoned or rejected and less able to make future relationships. I realise, as I said earlier, that decisions need to be based on the best interests of the child. This bill is not, nor should it be, about embedding or prioritising the rights of any adult. Yet the evidence suggests that the interests and the voice of children and young people are not being taken into account when it comes to foster carers. And in that respect, I think I would disagree with the assurances provided by the Minister earlier. As one foster carer explained to the Fostering Network, quote, "I believe it's important for fostered children to have contact with previous carers if they want it. They're entitled to have an extended family circle that can offer support or just friendship if they choose this. Most of the time this is discouraged by our local authority as they believe it may be unsettling and confusing for them. I don't believe this is to be true. Many of the children we have fostered who have contacted us themselves when they have left care just want to keep in touch. In a UK-wide survey of young people, around 1/3 of children and young people in care said that they had been prevented from keeping in touch with their former foster carers. Foster carers who had been prevented from maintaining contact with young people, 56% said it was the local authority who prevented them from doing so. I think these statistics make the case certainly to the Minister, for pushing local authorities to do more to support these relationships where that is in the interest of the child. And I think they also make the case for Amendment 78 in my name and in Jeremy Balfour and Fulton McGregor's. Given what the Minister had to say earlier, I'm minded not to press the amendment at this stage with a view to refining it and bringing it back at stage 3, but I'm conscious of the support that Jeremy and Fulton have given it, and would, I think, be interested to hear their comments before taking a final decision on what to do at this stage. But for now, thanks very much.
Okay, thank you, Liam. The following members have indicated that they'd like to speak. Liam Kerr, followed by Jeremy Balfour, followed by Fulton McGregor. Liam Kerr.
Thank you, Convener. Just very briefly, I'd like to express my support for the Minister's Amendment 54 and the attendant removal of the word practicable. This was a point made by several MSPs at stage 1, and I appreciate the Minister being prepared to listen to and meet with Neil Finlay and I to discuss this and ultimately to concede the point. So I'm very much in favour of that. And since I have the floor, very briefly, as I said in stage 1, I think there's merit in Rona Mackay's Amendment 77. I hear what she says about she's minded not to press it today, and I completely understand the reasons why, but I am pleased that she'll be looking to take that forward as this process develops. Thank you.
Thank you. Jeremy Balfour. Jeremy.
Thank you, Convener. I will be brief in my comments. I think there's two things we have to recognise here. There has been a lot of work done recently about attachment issues and the way that attachment affects children going forward into life. And particularly if someone has had a long-term relationship with a foster, to lose that contact can have a real damage on that child's life. So this is not, as Liam McArthur said, about giving foster individuals rights. It's about protecting children. And certainly the evidence that I have seen, and actually from my own emails and posts, is that local authorities do not always pursue this. And I would ask the Minister to refer to comments that she has made. I've had a number of contact both with those who have been through the system and also foster parents, and often local authorities do not prioritise this. In fact, we go to the opposite. They make it very difficult for this to happen. And I think we have to look at the best interest of the child. And if Liam McArthur doesn't move this this morning, then I hope that the Minister will look at this and some kind of amendment will be able to be brought forward at stage 3.
Thank you. And Fulton McGregor. Fulton.
Thank you, Convener. Starting with Amendment 54, just like Liam Kerr, I want to welcome that. I think that it's a good addition, and I think that the Minister has demonstrated the government's willingness to work with other people during the stage 1 evidence gathering. I did say that, through the looked after and accommodated review process, that should be being done anyway. However, I think that removing the word practicable does take away that doubt, and I think it's reassuring for everybody. So I want to offer my full support for that amendment. In terms of the amendment of which my name is supportive to, Liam McArthur, and also I want to put on record my thanks to the Foster Network, who provided a briefing, and also I had a brief discussion with them as well. I think that, well, the first thing I want to say is I think too often, perhaps in this debate and in other debates, we get involved in, as if one side of the coin is taking more in the interest of the child than the other. I think it's probably better to start from, a place where I think now everybody should be putting the interests of the child first, no matter what point they're arguing. And I think with, I would like to think that colleagues across the board would respect after 8 years in child protection, frontline child protection, that I would always be thinking that. And I feel, it's not great that I actually, even need to say that, because relationships, even although they might be about another individual, a grandparent, a foster carer, or whoever, it should always be the interests of the child that comes first. And I think we'd be a wee bit naive to think that there's not an issue with foster carers who have perhaps been long-term foster carers not, having an ongoing relationship with the child after they leave, and the impact that could have on the child. And often it's an afterthought. So I do think that there is definite relevance in this amendment. And I hear what the Minister said, and I do think that there is various issues with it, because it doesn't take into account when the foster care relationship may have broke down for really negative reasons for the child. So I think what the Minister's already said is that it needs to be worked in a way that it would be when it's been a positive relationship, and it will be positive for the child. And I think that could probably be done quite simply through guidance through the looked after and accommodated review process. And for children who are coming out of care and will no longer be in that process through other care plans that might be in place. So I do agree with the Minister's sentiment just now that it's not for the face of the bill, and my name on the amendment was also for probing reasons, and I agree with Liam MacArthur's stance in that respect, but we'd be interested to hear what the Minister's thinking ahead of stage 3. It is a complicated area, there's no doubt about that, but I do think it's definitely an issue worth airing here. It's been aired here, and it is something that needs to be looked at, because there is children who have perhaps got very long-term relationships with foster carers. They are suddenly removed, and because of other pressures and other relationships, they are not prioritised.
Minister, to wind up. Minister.
Thank you, Convener. I think I'm right in saying that Liam MacArthur said he wasn't going to move Amendment 78, because I was going to say that obviously it was opposed by Social Work Scotland, CELSIS, Adoption and Fostering Alliance, Adoption UK, and the Commissioner for Young People. So there are some quite significant complications in this at the moment. It's not at all straightforward, and I could not support it as currently drafted. However, I think this has been an interesting debate, and I do take on board some of the points that the members have raised, specifically around, children wanting to maintain contact with certain foster carers, and the local authorities making it very difficult for them to do that, and I'm very sympathetic to that. So I'm reflecting on this, that there might be a way to reflect the spirit of this amendment in a stage 3 amendment, or maybe a legislation is not the way to do that. Maybe this would be better addressed in guidance. So I'd be happy to speak to members who have an interest in this and see if we can find a way forward that would respect the spirit of this amendment.
Thank you. The question is that Amendment 54 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. No member has indicated dissent. Therefore, Amendment 54 is agreed to. I call Amendment 76 in the name of Alec Coe-Hamilton, already debated with Amendment 54. Liam MacArthur, to move or not move?
Not moved.
Not moved, thank you. And the question is not moved, 76. Call Amendment 77 in the name of Rona Mackay, already debated with Amendment 54. Rona Mackay, to move or not move?
Not move,
Rona.
Peter.
Thank
Not
you.
move.
Thank you. Amendment 77 is not moved. Call Amendment 55 in the name of the Minister, already debated with Amendment 54. Minister, to move formally. Minister?
Moved.
Thank you. Question is that Amendment 55 be agreed to. Are we all agreed? To indicate dissent, please put N in the chat box. No one has indicated dissent, therefore Amendment 55 is agreed to. I call Amendment 78 in the name of Liam MacArthur, already debated with Amendment 54. Liam MacArthur, to move or not move?
I think on the basis of the comments from my co-signatories and the offer from the Minister, I'll not move and look to develop something ahead of stage 3. Thank you.
Thank you, Liam. That means that Amendment 78 is not moved, and the question is that Section 10 be agreed to. Are we all agreed? We are all agreed. Amendment 31 in the name of the Minister, already debated with Amendment 54, and Minister to move formally. Minister?
Moved.
Thank you. The question is that Amendment 31 be agreed to. Are we all agreed? To indicate dissent, please put N in the chat box. No one has indicated dissent. Therefore, Amendment 31 is agreed. Paul, Amendment 79 in the name of Alec Cole-Hamilton, already debated with Amendment 60, and Liam MacArthur to move or not move.
Not moved, Convener.
Not moved, thank you. And that means Amendment 79 is not moved. The question is that Section 11 be agreed to. Are we all agreed? We are all agreed, thank you. We now move to Group 12, Alternative Methods of Dispute Resolution, and I call Amendment 57 in my name, grouped with Amendments 58 and 80. I'll move Amendment 57 and speak to all amendments in the group. In terms of Amendment 57 and 58, during the committee stage 1 scrutiny of the bill, various stakeholders stressed that an early resolution to family disputes reduced stress and trauma, stated that it helped prevent views and positions becoming entrenched, and acknowledged that courts are really the best place to resolve these family disputes. The committee heard that alternate dispute resolution could allow more bespoke and family-focused solutions to parenting disputes, but witnesses also identified one of the barriers to greater use of ADR was the lack of legal aid. Amendments 57 and 58 therefore aim to encourage greater use of alternative dispute resolution and help prevent children from experiencing the ordeal of a case coming to court. Furthermore, the amendments reflect the recommendations of the committee which they made on ADR at its stage 1 and in its report, which in turn reflect the recommendations that the committee previously made in its 2018 report, I Won't See You in Court. And these were namely that the Scottish Government and Scottish Legal Aid Board should explore making legal aid available for other forms of ADR, and that mandatory dispute information meetings should be piloted with the exception for domestic abuse cases. So more specifically, Amendment 57 makes provision for legal aid under Section 11 for not just mediation, but other types of ADR as well, including arbitration, corroborative law, and family group conferencing. It reflects the current procedure for the funding of mediation costs by SLAB, whereby a solicitor must be involved before the commencement of mediation, and provides the definitions of both advice and assistance and civil legal aid from the Legal Aid Scotland Act 1986. Now, I noticed that in Amendment 80, which is Liam MacArthur's amendment, we seem to be aiming in the same place, but this amendment states regulations should be laid within 12 months. However, given there is a process in place to provide limited legal aid for mediation, it seems reasonable that Scottish ministers should lay regulations and be able to do so within 6 months of commencement. Now turning to Amendment 58. This makes provision for Scottish ministers to introduce a pilot scheme for mandatory mediation information meetings. Under the pilot, before an order is made under Section 11, the parties would be required to attend an information meeting to discuss the alternative options available to resolve their dispute. And here it's important to understand that thereafter the parties decide whether to progress with ADR or to continue with court proceedings. So I stress again, only the information meeting about ADR or mediation is mandatory, and it's hoped, therefore, that having the opportunity to have this information, the parties will decide whether to go ahead. If not, then if they choose not to use ADR, they can continue to court proceedings to resolve family disputes. And importantly, the amendment makes it clear for the avoidance of doubt provision that cases involving domestic abuse would be exempt. In addition to this, it provides for judicial discretion in determining whether parties should be required, the mandatory aspect, for a mediation information if there are reasons why they consider that this would not be appropriate. Together, these amendments do, I believe, represent a positive and comprehensive way forward to ensure families can benefit from alternate dispute resolutions, to reach an early resolution to potentially damaging disputes, and avoid children being traumatised. I move Amendment 57 in my name and call Liam MacArthur to speak to Amendment 80 and other amendments in the group. Liam.
Thanks, Convener. As you say, Amendment 80 places a duty on Scottish ministers to make regulations about providing legal aid for funding ADR within 12 months of royal assent and requests Scottish ministers to consult with SLAM before making the regulations. It follows, as you've just outlined, a very similar approach to that set out in Amendment 57. Two Justice Committee reports in the recent past have made clear that ADR is being underutilised and that legal aid should be available for forms of ADR other than mediation. It was the consensus, if not the unanimous view of those who participated in the round table we held at the start of the parliamentary session. The benefits of the various forms of ADR compared to going to court are well established, particularly in cases involving children or anyone who might be considered vulnerable. As Children First point out, quote, courts are rarely the best place for resolving family disputes. Families should be given early help and support to resolve problems and disputes where it is safe and appropriate to do so before these issues reach the courts. In particular, we highlight the value of family group decision making as an important option to help resolve conflict and reduce stress. Without access to legal aid, however, going down the ADR route may not be an option for some who might benefit. Limiting legal aid to mediation also limits unnecessarily the cases in which it might safely and successfully be used. I appreciate the ADR may not be a sensible option in some cases. However, surely we should be doing more, particularly if our interest is in the best interest of the child, be encouraging its greater use in the resolution of family disputes. Whether in the form of my Amendment 80 or in your own Amendment 57, Convener, I hope committee colleagues will back the recommendation of our earlier reports and ensure more forms of ADR become a realistic option for many more of the people who need them.
Thank you, Liam. And an indication that Shona Robson would like to contribute, and then John Finney. Shona.
Thanks very much, Convener. I just have some concerns about Amendments 57 and 58. Firstly, as I understand it, and perhaps the Minister can clarify this, that there is work underway already to reform the legal aid system, and that should be done in a strategic way rather than piecemeal. So I'd be concerned about the process of doing that. But there's I guess a more kind of fundamental point that anyone who's read the Scottish Women's Aid briefing will have noted their concerns. They obviously are very clear that ADR is not appropriate in cases of domestic abuse. Now, I hear what the convener said, that in these cases that ADR wouldn't be appropriate, and she says that they're exempt. However, Women's Aid make a couple of points about that. They say that that with cases of domestic abuse, it's not always disclosed to authorities, whether that's the police, courts or social work. They have concerns about the practical implementation of these amendments in their current form. They say that they would not protect or safeguard children's rights. And they make the point that in relation to domestic abuse, that they lack confidence that the existing system could always identify where domestic abuse is taking place. So I think we have to take on board very carefully the concerns expressed by Scottish Women's Aid.
Thank you, Shona. And John.
Thank you very much indeed, Convener. I'll maybe just pick up on some of the points that Shona's just raised there. I mean, reform of the legal aid system. I think we've heard about that for a long time, and there are significant frustrations, not least with those connected with domestic violence and the difference between support and criminal and civil that we've touched on very often. I understood you making it very clear, Convener, the position that's replicated in the reports that we talked about, that there is no place for this approach to be adopted where domestic abuse is a factor. And I also, again, touch on what Shona talked about, the disclosure to the authorities. It's not always disclosed. And I get while that could be the case, and it would be very rarely that I would find myself taking issue with anything Aid would be dead. But a key phrase that both yourself and Liam McArthur made was about support, and we need to move things on. If everyone's agreed, and I understand everyone is, that the resolution of any dispute is not best located in a courtroom, then we must encourage this method of approach. So it would seem to me that there's no problems that are insurmountable. The understandable concerns that I've outlined, which I share, are the very reasons why I and indeed others are always going on about judicial training and an awareness of the very, very pernicious nature of domestic violence. I think we must encourage alternative dispute resolution.
Thank you, John. Liam McArthur. Liam.
Earlier, Convener John Finney suggested I was quicker out of the blocks than he was. Well, I think he's returned the favour there and outlined very much the views I was going to express. I absolutely accept the concerns that Shona Robeson has raised and that Scottish Women's Aid and others have been raising in relation to the deployment of ADR in the context of domestic abuse cases. That must remain, I think, a consideration for us, but it shouldn't prevent us opening up the option of a wider range of alternative dispute resolutions for those where there is no domestic abuse at play. And again, as John Finney has said, we've been round the houses on this a number of times now. The suggestion that either your amendment, Convener, or my amendment would constitute a piecemeal adaptation of legal aid seems to ignore the point that it's been piecemeal all along, and we've been waiting for a more fundamental review to open up access to ADR for far too long now. I think there's an opportunity with this bill to resolve that to some extent. Further reforms that may come in due course. But notwithstanding the very reasonable and legitimate concerns that Shona Robeson's raised, I think those are addressed in the way that either Amendment 57 or 80 are structured, and therefore I would encourage committee colleagues to back one or either.
Thank you, Liam. Minister?
Thank you, Convener. Amendments 57 and 80 direct that Scottish ministers make regulations to provide for legal aid to be available for parties to participate in ADR forums. Obviously, as it has been discussed, we are currently undertaking a root and branch review of the legal aid system. It is slightly delayed on where it might be already. The Legal Aid Payments Panel, which I'm sure the committee are aware of, were due to have their final meeting in March. And that didn't go ahead as a result of coronavirus. So we're slightly behind on that, but the committee have my commitment that we are still pushing ahead with that work. And a common criticism of the existing system is that it has been developed in that ad hoc way, reacting to changes in the law and with no sort of proper systemic and strategic review. And this criticism and issues about costs can obviously be addressed by a strategic review, which is what is being undertaken at the moment. And so whilst the Scottish Government welcomes the role which both arbitration and collaborative law can play to resolve disputes, they're unlikely to be cheap options, given the likely need for very senior lawyers to take part in that. And whilst the content of any future regulations under Amendments 57 and 80 is unclear, simply directing that legal aid should be available doesn't, of course, guarantee that it can be accessed, because civil legal aid is subject to the statutory tests of probable cause, reasonableness and financial eligibility. And advice and assistance is subject to prescribed financial eligibility criteria. So as well as our review of legal aid, we're also continuing our review of mediation and wider dispute resolution in cooperation with key stakeholders. And that review is aimed at improving access to justice by enabling access to a range of dispute resolution mechanisms in appropriate cases. On Amendment 58, the Government recognises the valuable role that ADR, including mediation, can play, and of course we provide funding to Relationship Scotland Network, and part of that funding is for mediation and for couple counselling. Legal aid resources are used to support mediation, and in 2018 the Scottish Government relaunched the parenting plan designed to help separating parents. And the Family Justice Modernisation Strategy commits us to improving that signposting and to information on alternatives to court, because I think the convener is quite right that court can end up being a very unpleasant experience at times, especially in areas of high conflict. And if it is possible to signpost people to other ways of resolving that dispute where it's appropriate, then that could be a good thing. But we can't support Amendment 58 because we don't consider it's necessary. There is an existing court rule which empowers the courts to send a Section 11 case to mediation already in place. And the Scottish Government has just sent a policy paper to the Family Law Committee of the Scottish Civil Justice Council to strengthen that rule. We proposed that the rule be extended to cover family cases such as financial provision or divorce cases, and that the rule should not be used where there has been domestic abuse. I think there's also some practical problems with these amendments. They're assuming that it could be known at the outset whether a case will ultimately end up with a Section 11 order being made, and that's sometimes not the case. Court proceedings might not begin as Section 11. They may become so where the court considers making an order under Section 11, and that could potentially be at a later stage in the proceedings. So the proposed requirement to provide funding for ADR might only arise midway through a court case or even after a Section 11 order has been made. So given these issues, given the Scottish Government's commitment to further work on ADR and promoting it in appropriate family cases, I would ask members not to press Amendments 57, 58 and 80.
Thank you, Minister. I'll wind up and press or withdraw the amendment. If I could just address this piecemeal reform that was referred to. We've been looking at this since 2018. A consultation has been promised for quite considerable time, and we've failed to make any progress on them. What the Amendment 57 does do is move on the provisions already in place for mediation to be legally aided to be added to other forms of dispute resolution. And it does so taking account of legal aid under Section 11, not just for mediation, but all these forms of alternate dispute, which reflects the current procedure and how it's funded, and that the fact that there must be a solicitor involved before they move forward. So I don't think the Minister's fears are justified in terms of the kind of concern she had about the Section 11. Also, it makes it absolutely clear there's an avoidance of doubt standalone provision that the mandatory mediation information would not apply or mediation at all would not apply to domestic abuse cases. And also in the requirement to go for an information meeting, then again, that can be looked at the discretion of the judge. And it may well be at parties or a party at that point do make some reference to a domestic abuse aspect or something else that can be taken into account. So it's very much a belt and braces provision in the drafting of this amendment. And on that basis, I think there's an opportunity here for extending ADR to be a much more satisfactory, less dramatic, and much preferable and satisfactory solution to these family disputes. And on that basis, I move Amendment 57 in my name. So the question is that Amendment 57 be agreed to. Are we all agreed to indicate dissent? Please type N in the chat box. There is dissent, therefore there will be a division. Stephen.
Thank you, Convener. Can I ask those members who are voting for Amendment 57 to put Y into the chat box now, please? And I ask those members who are voting against the amendment to put N in the chat box now, please. Can I ask any member wishing to abstain to put A into the chat box now, please? And I shall now read out the result of the vote. 5 members voted for. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, and Liam MacArthur. 4 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, and no members abstained. And I'll hand over to the convener to confirm the result.
Thank you. 5 members in favour, 4 against. Amendment 57 is agreed. The question is that Amendment 58 be agreed to. Are we all agreed? If agreed, say silent. To indicate dissent, type N in the chat box. There is dissent, therefore there will be a division. Stephen?
Thank you, convener. Can I ask those members who are voting for Amendment 58 to put a Y in the chat box now, please? Can I ask those members who are voting against the amendment to put an N in the chat box now, please? Can I ask any member wishing to abstain to put an A in the chat box now, please? I shall now read out the result of the vote. 5 members voted for. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney, Liam MacArthur. 4 members voted against. Alistair Allen, Fulton McGregor, Rowan Mackay, Shona Robertson. There were no abstentions. I'll hand over to the convener to confirm the result of the vote.
Thank you. 5 in favour, 4 against. Amendment 58 is therefore agreed to. I call Amendment 80 in the name of Liam MacArthur, already debated with Amendment 57. Liam MacArthur, to move or not move?
Convener, on the basis I'm not sure what it would add to 57 for the time being, I'll not move for now, but may come back with something else at stage 3.
Thank you very much. Amendment 80 is not moved. Call Amendment 81 in the name of Alec Cole-Hamilton, already debated with Amendment 60. Liam MacArthur, to move or not move?
Not moved.
Thank you. And Amendment 81 is not moved. The question is, I call Amendment 82 in the name of Alec Cole-Hamilton, already debated with Amendment 60. Liam MacArthur, to move or not move?
Not moved, Convener.
Not moved. Okay. I call Amendment 83 in the name of Liam MacArthur, already debated with Amendment 60. Liam MacArthur, to move or not move?
At this stage, I'm not going to move. I'll bring back at stage 3. Thanks.
Right. Amendment 83 is not moved. The question is that Section 12 be agreed to. Are we all agreed? We are all agreed, and that concludes the discussion of Amendment 12. I now break and suspend for a 5-minute comfort break. We now move to consideration of Group 13 amendments, and I call Amendment 32 in the name of the Minister, grouped with Amendment 43 and 44. Before I call the Minister to move Amendment 32, can I just say to everyone, there's a real prospect that we could complete these amendments today, so wherever possible, can you be succinct? Minister, to move Amendment 32 and speak to all amendments in the group. Minister.
Thank you. So on Amendments 32, 43 and 44, Section 13 of the Bill requires the Court to reassess the appointment of a curator at least every 6 months. And this currently applies to curators appointed before the provisions of the Bill come into force, as well as to any appointments made after commencement. However, I'm aware of concerns raised by the Scottish Courts and Tribunal Service during Stage 1 around the potential workability of this requirement insofar as it applies to appointments of curators made before the provisions come into force. And so in light of these issues, I propose to amend the provision so that the reassessment requirement will only apply to curators after the Section 13 comes into force. And my view is this takes a practical approach to the issues raised regarding workability, whilst protecting the best interests of children by ensuring that appointment of curators in new cases will be subject to periodic review. And I would add that obviously over time, as cases move on and appointments which predate commencement come to an end, the position will be reached where all appointments will be subject to the periodic review required by the Bill. I'm also proposing a minor structural amendment to the provisions to reflect the reality that the reassessment of the curator's appointment will occur routinely whenever the court has appointed a curator in Section 11 case, whether or not the court is considering making an order under Section 11 at the time. So I'd ask for the committee's support in these amendments. And I move Amendment 32, Convener.
Thank you, Minister. No member has indicated they wish to speak. So the question is that Amendment 32 be agreed to. Are we all agreed? To indicate dissent, please type N in the chat box. There's no indication of dissent, therefore Amendment 32 is agreed. The question is that Section 13 be agreed to. Are we all agreed? Again, indicate with N to record dissent. There's no recording of dissent, therefore Section 13 is agreed to. Call Amendment 33 in the name of the Minister, already debated with Amendment 64. Minister, to move formally. Minister?
Formally moved. Formally
Thank
moved.
you. Call Amendment 33A in the name of Rona Mackay, already debated with Amendment 64. Rona, to move or not move?
Not move.
Thank you. Amendment 33A is not moved. The question is Amendment 33. as amended be agreed to, well, I don't think it is amended, is it? Is that right, Stephen? Can I just check that if it was withdrawn at 33A?
That's correct, Convener. Rona Mackay did not move Amendment 33A, so therefore the question is Amendment 33 be agreed to.
Thank you for that clarification. The question is Amendment 33 be agreed to. Are we all agreed? Anyone that wishes to dissent, please type in. John, I think, John, there is an indication of dissent, therefore there will be a division. Stephen.
Oh, no.
Thank you. So if there is a division on Amendment 33 in the name of Minister Ash Denham, therefore, can I ask those members who are voting for the amendment to put a Y in the chat box now, please? Can I ask those members who are voting against the amendment to put an N in the chat box now, please? Can I ask any member wishing to abstain to put A in the chat box now, please? And I shall now read out the result of the vote. There were 7 members in favour. They were Alistair Allen, Fulton McGregor, Rona Mackay, Shona Robertson, Liam Kerr, Margaret Mitchell, and James Kelly. There were 2 against. That was John Finney and Liam MacArthur. There were no abstentions, and I shall pass over to you, Convener, to confirm the result of the vote.
Thank you. 7 in favour, 2 against. Amendment 33 is agreed. The question is that section 14 be agreed to. Are we all agreed? Indicate dissent by pressing N or typing N. There is no dissent, therefore section 4 is agreed to. Call amendments 34, 35 and 36, all in the name of the Minister and all previously debated. I invite the Minister to move amendments 34 to 36 en bloc. Minister?
Moved en bloc, Convener.
Oh, thank you, Rona, on behalf of. Does any member object to a single question being put on amendments 34 to 36? If so, please indicate N in the chat box. No one has done so, so the question is that amendments 34 and 36 are agreed to. Are we all agreed? No one has indicated dissent, so we are all agreed. The question is that section 15 be agreed to. Are we all agreed? And again, N in the dissent box. No one has done so, so section 15 is agreed. We now move to group 14, Child Advocacy Services, and I call amendment 84 in the name of Liam MacArthur in a group on its own. Liam to move and speak to amendment 84. Liam.
Thank you, Convener. Amendment 84 creates a duty on Scottish ministers to ensure the availability to child advocacy services in Section 11 cases. Colleagues will recall the powerful evidence that was heard by the committee about the need to strengthen the so-called infrastructure for taking children's view. This was one of the key asks in our Stage 1 report. In their written submissions, Dr Morrison, Dr Friskney and Professor Tisdale argued, and I quote, "The strongest and most consistent request from children and young people in Scotland who have been involved in contested contact proceedings is to have a child support worker. Without addressing this now, children's participation throughout the legal process risks being dealt with inconsistently on an ad hoc basis and thus marginalised. We recommend provision be put into primary legislation with the ability to then link developments to other advocacy roles. Relationship Scotland, and here I remind the committee of my interest again, similarly suggested, and I quote, "The provision of child support workers seems to be fundamental to supporting the main policy objectives of this bill. There would be significant benefit from including the provision in relation to child support workers in the Children's Scotland Bill legislation to ensure action is taken sooner rather than later." A number of other organisations echoed those views, including Planned Child Law Assist, the Scottish Child Law Centre, Partners in Advocacy and the Scottish Independent Advocacy Alliance, amongst others. The amendment is not overly prescriptive. It merely adds a system-wide responsibility for a service that should already be available. However, I believe that by creating this duty and placing it on the face of the bill, a layer of assurance, necessary assurance, would be added. I look forward to hearing the views of others, including the Minister, but for the time being, I have pleasure in moving Amendment 84 in my name, Convener.
Thank you, Liam. Shona Robson.
Thanks, Convener. I've got a lot of sympathy with what Lee McArthur is trying to achieve here. I just wonder, one of the issues raised with me is around the possibility of a number of adults being involved in a child's life. So if you had a support worker for various types of situation, it would be useful to hear Lee McArthur's view on that. I mean, how would you avoid a plethora of adults becoming involved in a child's life for various aspects of their life? It would be useful because that concern, as I say, has been raised with me around this. So it would be helpful to hear his view on that.
And John Finney, and then I'll let you respond in your wind up, Liam, if that's okay. John Finney.
Thank you, Convener. Yes, I speak in support of colleague Lee McArthur's comments. He talked about powerful evidence, and I imagine an argument can be made that a lot of the evidence we've heard in support of increased advocacy is from advocacy groups. So perhaps you could argue, cynically, no surprise there. But what, of course, we do know is, pretty much like mediation and early intervention, support can often stop situations escalating. And we know the multiplicity of issues that can be faced. And I think Shona Robson poses a reasonable question. But as my colleague Lee McArthur says, there's a belief by many that this should be in place in any case. And I think, certainly if we're putting the focus on the interests of the child, then this, in the scheme of things, would seem to be a very modest proposal, and it certainly enjoys my support. Thank you.
Okay, thank you. No other members have indicated that they want to speak. So can I just say that it does seem to me that having access to advocacy services is certainly in the best interests of the child. Minister.
Thank you. So in relation to Amendment 84, I appreciate the aims of this amendment. However, I can't support it at this time. I'm aware that a number of stakeholders have suggested that the bill should introduce a formal system of child support workers. And so I have committed before stage 3 to bringing forward more detailed plans with timescales on the work that the Scottish Government plans to undertake to meet our commitment to ensuring that children's advocacy is available. I've also committed to producing a public paper in advance of stage 3, which sets out the ways in which children can give their views in family court cases. And I trust this will reassure the member that I do appreciate his concerns and that I am actively looking at this area. And whilst I appreciate what the member and others have said, that child support workers can play an important role in ensuring children are able to give their views, we know that some children may already have a child support worker or an advocacy worker in other contexts, such as children's hearings or in criminal proceedings. And there are concerns about bringing another adult into that mix and whether that would be in the child's best interest. Further, if we were to introduce a system of child support workers, we need to ensure that all those individuals were meeting minimum standards, that they were trained appropriately, they had the right type of expertise and experience, and that might mean then establishing a list of them in the way that we have a list of the child a list of child support workers in the same way that of the other list that we are proposing to establish. This, of course, would take some time to work through, and consideration would also need to be given to the effects of regulation on the existing child support workers. So there is quite a few issues here that would need to be worked on, and so for those reasons I would ask the member not to press this amendment at this time.
Liam MacArthur to wind up, press or withdraw. Liam.
Thank you, and thank you, Convener, for your comments, and Shona, John Finney and the Minister as well. I appreciate very much John Finney's strong support and the arguments that he made. I think Shona Robertson raises legitimate issues around the potential impact in terms of a multiplicity of adults being involved in supporting a child. And fundamentally, this comes back to decisions being taken in the best interest of the child, and I'm sure where there's already a support worker in place providing the necessary support, any court would take that into consideration if there were any concerns that adding additional support may dilute the benefit rather than augment it. I'm sure that would be borne in mind. When I come back to the point, I outlined a number of organisations that are supportive of this. I take John Finney's point about many of those being advocacy organisations, but a number of them are not. Children's First and Scottish Women's Aid are others who support this amendment. And therefore, I think, as much as anything, providing a degree of reassurance that there's a consistency of what a child has a right to expect throughout the system. I am going to press ahead with this amendment, Amendment 84, to put it on the face of the bill.
Thank you. The question is Amendment 84 be agreed to. Are we all agreed? To indicate dissent, please type N in the box. And there is dissent, therefore there will be a division. Stephen. Amendment 84.
Thank you, Convener. Therefore, can I ask those members who are voting for Amendment 84, put a Y in the chat box now, please. Can I ask those members who are voting against the amendment to put an N in the chat box now, please? Can I ask any member wishing to abstain to put an A in the chat box now, please? And I shall read out the result of the vote. 5 members voted in favour. They were Liam Kerr, Margaret Mitchell, James Kelly, John Finney and Liam MacArthur. 4 voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay and Shona Robertson. I shall hand over to the convener to confirm the result of the vote.
Thank you. 5 in favour, 4 against. Amendment 84 is agreed to. Call Amendment 37 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister?
Moved.
Thank you. Question is Amendment 37 be agreed to. Are we all agreed? To indicate dissent, please type N in the box. There are no indications of dissent, therefore Amendment 37 is agreed to. The question, call Amendment 38 in the name of the Minister, already debated with Amendment 1. Minister to move formally. Minister?
Moved.
Thank you. The question is Amendment 8 be agreed to. Are we all agreed? To indicate dissent, please type N in the box. There are no indications of dissent, therefore Amendment 38 is agreed to. We now move on to Group 15, failure to obey Section 11 order. Call Amendment 39 in the name of the Minister and a group of its own. Minister to move and speak to Amendment 39. Minister.
Thank you, Convener. Amendment 39 gives Scottish Ministers power by regulations to amend the list of persons who may be appointed by the court to investigate the reasons for actual or alleged non-compliance with an order the court has made under Section 11 of the 95 Act. And this paves the way for flexibility on who can investigate the reasons for actual or alleged non-compliance with the Section 11 order. The bill, as introduced, allows the court to appoint a child welfare reporter to investigate, but this amendment will allow ministers to make regulations enabling other professionals to perform that investigative role, and these regulations will be subject to the affirmative procedure. I hope members will agree that this amendment is important, ensuring that there's flexibility around the ways in which the court can investigate the reasons for non-compliance, and I move Amendment 39.
Thank you, Minister. No members have indicated they wish to speak, so the question is that Amendment 39 be agreed. Are we all agreed? I pen in the dissent box if you do not agree. No members indicated they do not agree, therefore Amendment 39 is agreed. The question is that Section 16 be agreed to. Are we all agreed? Again, N in dissent box if you disagree. No member has indicated they disagree, therefore Section 16 is agreed to. We now move to Group 16, Specialist Judiciary. I call Amendment 59 in the name of Jeremy Balfour, in a group on its own. Jeremy, to move and speak to Amendment 39. And can I just remember, members, we're so very near the end, the clock is ticking, succinctness would be appreciated. Jeremy.
Convener, thank you. I will be as brief. Yeah, I will be as brief as possible, but can I move Amendment 59 in my name? Throughout this morning and throughout the working on this bill, the child's best interest is at the heart of that. And it is very rare for a child's best interest ever to end up in the Sheriff Court. From historic, I've done family law many years ago, going to the Sheriff Court for any kind of case was always difficult, and particularly for children when we had to either appear or give their views to a sheriff. Sheriffs predominantly do criminal law, and that is their bread and butter. And often, as we've heard before, we do not simply have the judicial training in regard to family law and in particular children's issues. What this amendment does is simply to allow sheriffs who are specialised in family law to hear these type of cases. Within the Court of Session, this has already been set up for commercial actions, where there's one judge hears all commercial cases, and it would seem appropriate to me that this would be a way forward. Smaller jurisdictions, for smaller sheriffdoms, it may not be possible to have one sheriff with that speciality, and my amendment allows those then to come in and deal with those cases. And then I will be in the best interest of a child if there's someone with that speciality who has got that training and who's dealing with it day in, day out. And so I hope the committee will accept Amendment 59. Thank you, Convener.
Thank you. No other members have indicated that they wish to contribute. So, Minister.
Thank you, Convener. Clearly, the deployment of the judiciary is a matter for the Lord President and the Sheriff's Principal. And so the Scottish Government doesn't support this amendment, first of all, because we don't think it's necessary. There are existing powers on judicial specialisation in the Court Reform Scotland Act of 2014. So I don't think there is a need to legislate again here in similar terms. And secondly, the amendment refers specifically to cases brought under Section 11 of the Children's Scotland Act 95. And in practice, cases can be multi-crave. The pursuer may be seeking a variety of outcomes in a single court action. So the pursuer might seek a divorce, financial provision, a civil protection order such as an interdict against domestic abuse, and a Section 11 order. So that's not just a drafting point against the amendment, it is a point of substance, as there would be questioned as to whether any specialisation was just to apply to Section 11 or to the whole case. Cases are not always brought under Section 11, as the amendment supposes. Courts consider and make Section 11 orders in proceedings which don't start out as Section 11 proceedings, and if this is required, the case to be transferred to a specialist sheriff, then the delay, expense and negative impact on the child, I think, would be obvious at that point. I think there would be cost implications for this as well. If sheriffs were asked to specialise in Section 11 cases only, that might reduce the flexibility in relation to deployment, and so need to appoint more sheriffs. So in summary, I recognise there is a legitimate debate to be had here on specialisation, but there are existing powers on specialisation in the Courts Reform Act, and so I would ask the member not to press this amendment.
Thank you. Jeremy Balfour, wind up, press or withdraw. Jeremy.
Just very briefly, this power is used within certain sergeants already, and I think there's a slight contradiction within what the Minister said. She said that the power is there, and then she comes out and said, well, actually, we shouldn't be using that power because of that. I do think this is a way forward, and I think in the reason section 11 is that it deals with children particularly, and I think they do need the special training that these cells should have. So I do press this amendment.
The question is, Amendment 59 be agreed to? Are we all agree? Members can indicate dissent by putting N in the box. There is dissent, therefore there will be a division. Stephen.
Thank you. Can I ask members who are voting for Amendment 59 put a Y in the chat box now, please? Can I ask those members who are voting against the amendment to put an N in the chat box now, please? Can I ask any member wishing to abstain to put an A in the chat box now, please? I shall read out the result of the vote. 2 members voted in favour. They were Liam Kerr and Margaret Mitchell. And 7 members voted against. They were Alistair Allen, Fulton McGregor, Rona Mackay, Jonah Robertson, James Kelly, Don Finney and Liam MacArthur. And I shall pass over to you, Convener, to confirm the result of the vote.
Thank you. 2 in favour, 7 against. Amendment 59 is not agreed. The question is that sections 17 to 20 be agreed. Are we all agreed? Again, indicate your dissent in the chat box. No one has indicated their dissent, and therefore sections 17 to 20 are agreed. Amendment 40 is now called in the name of the Minister, already debated with Amendment 29. Minister to move formally. Minister.
Moved.
Thank you. Question is Amendment 40 be agreed to? Are we all agreed? Indicate dissent by putting N in the chat box. No one has done so, therefore Amendment 40 is agreed to. We now move to Group 17, delay in proceedings, and I call Amendment 85 in the name of Fulton McGregor on a group on its own. Fulton to move and speak to Amendment 85. Fulton.
Thank you, Convener. This amendment seeks to deal with an issue that the committee took considerable evidence on at stage 1, and that is delays in proceedings. And I'm very grateful to all organisations who have submitted briefings and to the Minister for discussing it with me. I think it is clear that there is a majority of opinion that long and unnecessary delays are not in a child's best interests. They need to know if and in what circumstances they can have meetings with their other parent, or indeed if a court feels that this would not be safe. Children need to know this. Children's hearing system is renowned for bringing about quick and decisive action. Therefore, children subject to these proceedings often have issues relating to spending time with their parents dealt with swiftly, and these fully explained to them. And as MSPs, we've all heard of cases which have lasted months and even years. It's no one's fault that that's the case, but it's not acceptable, and we have a duty to consider how the system can work better. And certainly through stage 1 process, there was much evidence on that. I appreciate that the Minister may also indicate that she agrees with the premise of this amendment, and I'm very grateful for the input from Chair Parenting Scotland, the Children and Young People's Commissioner, and the Women's Aid Children's First, the latter of whom states in their joint briefing for today that there is recognition of the intention behind this amendment. I guess that's unsurprising, given that their organisations have, like many of us, witnessed first-hand the impact of huge delays on children, young people and their families. I want to reiterate that this amendment is, of course, with the best interests of children and not of the organisations which work within the system to deliver results. I recognise that the timescale does place some restrictions and clearly would not factor in those situations when it may be in the best interest of a child to exceed 60 days. I'm also aware of concerns that if this amendment was to be passed today, courts may become more inclined to make cautious orders in the first instance, not wanting to commit. So as a bit of background for the committee, my initial amendment didn't actually include a timescale, but when drafting with the legislation team, I took advice and decided to include one. And so on that basis, I'm content for this to sit as a probing amendment just now, and I've already expressed this to the Minister. I'd be grateful if something could be worked up in legislation and brought back at stage 3 on the face of the bill or otherwise. Again, I'm open-minded to that, but something that captures the intent of this amendment but takes into account the need for some delay, but of course only when that is in the child's best interest. I look forward to hearing other members if they're going to contribute, and of course the Minister on this.
Liam Kerr.
Thank you, and thank you to Mr McGregor for that. Yeah, he's right, the premise is good, of course it is. The question, were he looking to press this, that I'd be interested to know is what would happen if the dispute isn't resolved within 60 days after commencement. I mean, is there some kind of sanction? Is there something else in the legislation that I'm missing? And also, just picking up the point that he made quite rightly in there, what would happen if it wasn't in the best interest of the child to complete this within 60 days? But presumably, if he's not pressing this, these are the sorts of questions that might inform the discussion as he takes this forward. Thank you.
Okay, and I'll hear from the Minister, and then Fulton can address these points in his wind-up. Minister.
Thank you. So on Amendment 85, obviously lengthy court proceedings and undue delays in cases relating to children are not in the child's best interest, and that's why in Section 21 of the bill provides that the court must have regard to any risk of prejudice to the child's welfare that delay would pose. And that complements work that we're doing on case that is also being done on case management by the Family Law Committee of the Scottish Civil Justice Council. I think Liam Kerr is right to raise questions. There are questions about what would happen if the deadline is missed and so on in this suggested amendment. Cases can be very complex, and courts are going to need at times consider all aspects, which may be time consuming. Forcing the court into making a decision to a particular time frame, I feel, could have a number of unintended consequences. So while I share the members' concern about delay in these cases, I won't be able to support this amendment. I think the right approach is the one that's taken in the bill already, combined with the case management work that I've referred to. And so I think the member has indicated that he's not going to press, but if he was, I would be advising him not to press the amendment at this time. Thank you.
Thank you, Minister. Fulton McGregor to wind up and press or withdraw. Fulton.
Thanks to the Minister and to Liam Kerr. Yeah, I mean, I feel like I was pretty clear in the opening remarks that I wasn't overly keen on a suggested timescale myself, and when I took further advice on that and to put timescale in, that is what ultimately led it to me being a probing amendment. So I have been clear on that. I do have issues with tight timescales as well. I think Liam Kerr and the Minister have relayed that. I think that I'm hearing what the Minister is saying, and I'm not minded to press it at this stage, and perhaps come back with something else at stage 3, which would be more manageable and in line with the legislation. So happy to leave it at that.
Right, and are you pressing or withdrawing, Fulton?
Withdrawing, Convener.
Does any member object to this amendment being withdrawn? No member has indicated, therefore Amendment 85 is withdrawn. Call Amendment 41 in the name of the Minister, already debated, with Amendment 29. Minister to move formally.
Moved.
Thank you. The question is that Amendment 41 be agreed to. Are we all agreed to indicate dissent? Please type in the chat box. No one has indicated dissent, and therefore Amendment 41 is agreed to. Call Amendment 42 in the name of the Minister, already debated, with Amendment 29. Minister to move formally. Minister.
Moved.
Thank you. The question is Amendment 42 be agreed to. Are we all agreed Please indicate dissent by putting N in the chat box. No one has indicated dissent, therefore Amendment 42 is agreed to. The question is that Section 21 be agreed to. Are we all agreed? No one has indicated dissent, therefore we are all agreed. We now move to our last group, which is review of effective act, and call Amendment 86 in the name of Liam McArthur in a group on its own. Liam to move and speak to Amendment 86. Liam.
Thanks, Convener. I'll try to be brief. This amendment provides for a review of the Act to be completed in 3 years from royal assent, and a report to be published and laid before Parliament. The report should include the steps, if any, that Scottish ministers propose to take to further improve the participation of children in court processes. As with my earlier Amendment 84, 86 reflects this committee's recommendation that the Scottish Government should amend the bill to provide for a review of the impact of the bill on children's participation after 3 years following commencement. Again, as I said previously, Dr Morrison, Dr Friskney and Professor Tisdale expressed concern that the financial memorandum makes no provision for an infrastructure to support children to express their views. This was supported by Scottish Women's Aid, who suggested that, quote, monitoring and review of the bill's implementation is required to ensure that children's rights are realised in practice. In order to provide such a reassurance, a greater confidence, in fact, that children's rights will be realised in practice, I hope colleagues will support my Amendment 86, which I move.
Thank you. Liam Kerr? Did you indicate that you wanted to move, or was that for the last amendment, Liam?
That was for the last amendment, but I'm sure what Mr McArthur said was very important.
I'll just say that I think I'm very supportive of this amendment and look forward to hearing from the Minister. Minister.
I understand the point behind Amendment 86, but I'm not convinced that 3 years after royal assent is the right timetable. And I think the committee will understand that it will take time to implement some of the measures in the bill. The financial memorandum which goes with the bill has indicated that the regulation of child welfare reporters and contact centres may not be in place in advance of 2023, given the need and the commitment that we've made to carry out thorough consultations in all of those areas. So I don't think that 3 years is the right timetable. But if Liam McArthur was to bring this amendment back at a later stage, potentially with a different timetable, that would be more appropriate, because it would allow the bill's operation to be more accurately assessed, then potentially I would support that if I had a different timetable. Thank you.
And Liam McArthur to wind up or press or withdraw Amendment 86. Liam.
Thanks, Convener. Thanks for your support. Thanks to Liam Kerr for his inadvertent support, and thanks to the Minister for her offer. I recognise that timeframes for these things can be somewhat arbitrary. I take on board the concerns she has about preempting some of the work that obviously will need to be taken forward following royal assent to the bill. So on that basis, I won't move the amendment now, come back at stage 3 with something that is perhaps more in keeping with the timeframes we need to see.
Does anyone object to Amendment 86 being withdrawn? Please indicate N in the box if you do. There's no indication of that, therefore Amendment 86 is withdrawn. Call Amendment 43 in the name of the Minister, already debated with Amendment 32. Minister to move formally. Minister?
Moved.
Thank you. The question is Amendment 43 be agreed to. Are we all agreed? Please indicate N in the box if you wish to dissent. There's been no indication of dissent, therefore Amendment 43 is agreed. Call Amendment 44 in the name of the Minister, already debated with Amendment 32. Minister to move formally. Minister?
Moved.
Thank you. The question is Amendment 44 be agreed to. Are we all agreed? Type N in the box if you dissent. There has been no indication of dissent, therefore Amendment 44 is agreed to. The question is that Section 22 be agreed to. Are we all agreed? We are all agreed. Thank you. The question is that Sections 23 to 25 be agreed. Are we all agreed? We are all agreed. Thank you. And the question is, the long title be agreed to. Are we all agreed? We are all agreed. And that ends our stage 2 consideration of the bill. Our next meeting of the committee will be scheduled at an appropriate date, and this will be notified in the business bulletin and via the committee's social media. In the meantime, any follow-up scrutiny issues will be dealt with by correspondence which are published on our website. And given the time, then our last item will also be dealt with by way of correspondence. And that being the case, then I thank all members for your attendance today, and that concludes the 16th meeting of 2020. Now formally close this meeting.